Good afternoon. The Senate will come back to order. Order of business number 6, messages from the Assembly.
Assembly Chamber, Carson City, July 31st, 2020. To the Honorable Senate, I have the honor to inform your Honorable Body that the Assembly on this day passed Assembly Bill number 1. Also, I have the honor to inform your Honorable Body that the Assembly on this day passed as amended Assembly Bill number 2. Signed, Carol Ayala Sala, Assistant Chief Clerk of the Assembly. End of messages.
Thank you. Order of business number 9, motions, resolutions, and notices.
Senate Joint Resolution number 1, introduced by Senate Committee of the Whole, proposes to amend Nevada Constitution to revise provisions governing taxation of minerals extracted in the state. End of resolution.
Thank you. Senator Canizaro.
Thank you, Madam President. I move to refer Senate Joint Resolution number 1 to the Committee of the Whole.
Thank you. Senator Canizaro has referred Senate Joint Resolution number 1 to the Committee of the Whole. Any objections to the referral? If not, so ordered.
That concludes order of business number 9.
All right. Order of business number 10. A second here, guys. Introduction, first reading, and reference.
Assembly Bill number 1, introduced by Assembly Committee of the Whole, ratifies certain technical corrections made to NRS and statutes of Nevada. End of bill. And Assembly Bill number 2, introduced by Assembly Committee of the Whole, revises and clarifies provisions relating to Legislative Department of State Government. End of bills.
Thank you. Senator Canizaro. Oh, sorry. Hey, Senator Ratty.
Thank you, Madam President. I would move to refer AB 1 and AB 2 to the Committee of the Whole.
Thank you. Senator Ratty has moved to refer Assembly Bill 1 and Assembly Bill 2 to the Committee of the Whole. Any objections to the referral? If not, so ordered.
And that concludes order of business number 10.
Thank you. Order of business number 9, motions, resolutions, and notices. Senator Canizaro.
Thank you, Madam President. I move that the Senate resolve itself into a Committee of the Whole for the purpose of considering AB number 2, SJR 1, AB number 1, and other matters as outlined in the Governor's proclamation, with Senator Canizaro serving as the chair and Senator Ratty serving as the vice chair.
Thank you. You have heard Senator Canizaro make a motion. Any remarks? All right. Hearing none. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are in recess.
Committee of the Whole will come to order. Committee members, you will note on our, and for those of you who are following along with us online and looking to participate, the way that this Committee of the Whole will work is we've got 3 items on our agenda at this point in time. We will start with Assembly Bill number 2, which revises and clarifies provisions relating to the legislative department of the state government. Once we hear testimony on this bill, we will proceed, as we have been, with taking public testimony in favor, in opposition, and finally in neutral on the bill. I will remind committee members that we will be giving everyone an opportunity to ask questions if they so choose and have questions on the bill, but please, we will keep that to one opportunity to ask questions for every member rather than to have multiple chances, since we do have quite a few items on our agenda and are going to, with intention, move through those items. For those of you who are watching online, we will also have limits on our amount for public testimony. As you've seen in the past, we've been doing 2-minute limits, but we will take each of those opportunities for testimony on each of the bills after the presentation and testimony on those specific bills. So with that, we will move and open the hearing on Assembly Bill number 2, which revises and clarifies provisions relating to the Legislative Department of State Government. We will be joined virtually with Ms. Brenda Erdos, who is the Executive Director of the Legislative Council Bureau. And whenever you are ready, Ms. Erdos, to walk us through Assembly Bill number 2, we'll turn the floor over to you, and then we will proceed with questions from the committee.
Chair, I would like to start by letting you know that NRS 218F 150 prohibits the director and other officers and employees of the Legislative Council Bureau from opposing or urging the passage of legislation unless the person's duties require them to make recommendations to the legislature. I believe that this bill is somewhere in the middle between these two situations. For example, the first provisions in the bill, sections 2 to 9, relate to the use of remote technology systems in interim committees. In my role as director, I recommend to you that you enact these provisions to protect the process that allows remote participation by specifying how the process should work in the interim, and by providing penalties for interruption of these virtual meetings held both during the session and during the interim. But only if you wish to continue to allow remote participation during the public health crisis caused by the COVID-19 pandemic. I'll provide a brief summary of the provisions, and I'm happy to answer questions. Sections 2 through 9 of AB 2R1 provide for the use during the public health crisis caused by the COVID-19 pandemic of remote technology systems by interim, advisory, and similar committees that are staffed by LCB employees and have members who are legislators. Those are committees like the Administration of Justice or the Committee on License Plates. These provisions specifically authorize interim committees to use remote technology systems for committee meetings during the public health crisis caused by COVID-19 pandemic. Sections 2 to 9 do not apply to the use of remote technology systems to facilitate legislative sessions. Because of the use of remote technology systems for legislative sessions is governed by the rules adopted by each House pursuant to their constitutional authority to determine the rules of their proceedings. However, sections 15 and 16 of AB 2R1 do apply to the use of remote technology during the legislative session and the interim. These sections specifically extend the existing provisions that prohibit conduct constituting unlawful interference with the legislative process by adding specific examples, including actions relating to the use of remote technology. The penalty for interfering with the legislative process is a gross misdemeanor pursuant to 218A 915. Section 17 is a different topic. It is actually related, but AB2 of AB2R1 is section 17 in the bill is in there because we've been asked several times through the years whether a joint resolution proposing an amendment to the Nevada Constitution could be passed for the first time during a special session, including recently. When we researched the issue, we determined that Section 1 of Article 16 does, by its plain language, allow a proposed constitutional amendment to be adopted but that we do not currently have a method in our existing statutes to comply with the 3-month notice requirement during an even numbered year because of our pattern of printing statutes of Nevada only once every 2 years. Section 17 remedies this problem by providing that separate publication of joint resolutions that propose constitutional amendments immediately following the adoption of joint resolutions. Some, like the addition of the title of or section 10 through 12 through 14 and 19 through 25 of AB 2R1, make some modifications to the organization of the LCB. Some, like the addition of the title of Division Chief for the Assembly and Senate Fiscal Analyst and the Chief of the Administrative Division, are not substantive. They are instead merely helpful in making the organization of the LCB more readily apparent. Others are related to the appointment of a general counsel that was approved by the Legislative Commission at its June 5th meeting. For many years, we've experienced times when the legal division was unable to act on behalf of the legislature because we were conflicted out. The problem was that with the Legislative Council being responsible for all of the attorneys in the legal division, if we advised the legislature during an investigatory stages of an event, we were then conflicted out from advising the legislature during the adjudicatory stages, and outside counsel had to be found either by borrowing an attorney from one of the counties, as we did in the Augustine impeachment proceedings, or by contracting with outside counsel in the manner that resulted in the expulsion of former Assemblyman Brooks. And this type of issue has become more prevalent in the past few sessions with various occurrences of issues such as sexual harassment complaints. The same thing happens there. With the appointment of a second division chief in the legal division, much like the fiscal division, the legal division will now be able to provide an appropriate legal separation for issues that may arise in the future. In addition, and one of the things that makes this more of an emergency to us is that we believe that this ability to provide legal separation within the division may also be helpful in ensuring that legislators who are involved in litigation against the state may choose to work with on BDRs and legal opinions with attorneys who are not working on that litigation, so that wall might really work there. I'm happy to answer any questions that you may have.
Great, thank you very much. We appreciate you being able to walk us through pieces of that bill. We will start with questions from members of the committee. Senator Pickard.
Thank you, Madam Chair, and thank you, Ms. Erdos, for presenting the bill. Just one question, and it has to do with the last thing we talked about, or that you talked about, with respect to the division, the firewall that this purports to create. Is it fair to say then that without this structure, it is improper for the Legislative Council to both represent and advise the members of the body?
Thank you for the question, Senator Pickard. I believe that question was actually answered by the latest Supreme Court decision in this case. There was a 5-2 decision saying that the attorneys were not conflicted out from giving that advice. However, again, the problem that I saw is that it was clear that people were they were uncomfortable, and that's why we were seeking to make this work better for all of us.
So I guess what I hear you saying is that this legislation is unnecessary. It just makes us feel better?
No, I think it is necessary for, we've spent a fair amount of money over the years when we hired counsel to handle the adjudicatory side of the issues that have come through. And I think for that reason, it will be very valuable to the legislature and very cost effective as well.
Thank you, and thank you, Madam Chair.
Senator Keycover.
Thank you, Madam Chair. Thank you, Ms. Erdos. I have a couple of questions. The first relates to how we define when we are meeting during the public health crisis caused by the COVID-19 pandemic. I don't see a reference to the governor's declaration of emergency or anything that spells out when those systems take effect.
In this case, we opted to leave that a little bit more open, and so that decision could be made by the Legislative Commission, for example, for the LCB, and then for by the Interim Finance Committee for itself and its programs. We felt like having this much of our organization be directed towards a different branch of government might be sort of an issue in the future, and so we intentionally left it open. So basically, it would be up to the body to determine when the pandemic is succeeded so far that you don't need this anymore.
Okay, thank you. And then in section 17, when it comes to the immediate publication of the constitutional amendment, can you walk through just sort of the process on that? I assume you're talking about physically printing something and then publishing it. Maybe I'm wrong. Can you spell that out a little bit more clearly?
Oh. You're actually completely correct. What we're looking at doing is something much like the advance sheets that you've seen, the paperback advance sheets that would be just stitch bound, depending on how much of a resolution it was. We're thinking that it would be a fairly small publication, and that it would be routed to all the same people that by statute we are required to provide statutes of Nevada to. That's how we deal with the advance sheets, and we were just going to follow that same manner of getting this notice out.
So if
it would also be up on our website as well.
Okay, thank you for that. So if, for example, an advance sheet needed to be produced by August 3rd, when would a resolution have to be passed by in order to meet that deadline for you?
August 3rd, I guess. The printing office is pretty amazing in how they turn around bills, and I believe that, again, this would be a fairly small, if it's a fairly small publication, that it can be done very quickly.
Same day. Thank you. Appreciate it.
Senator Settlemeyer.
Thank you, Madam Chair. I was kind of curious, following up on one of my colleagues' comments. If Section 17 did not pass, when would it have to be passed by?
I think if we're talking about something that would be in this special session, if it did not pass, then I don't believe that this would work, because there is currently no recognized in the statute. I mean, I suspect that we would go ahead and put something out, and it should work, but it would be subject to, I think, challenge. This is trying to help with that potential for challenge.
Okay, I appreciate it. So basically it's trying to preempt a problem that could occur legally. One of the questions I had within Section 9, has there been much problems in other communities that have done remote in person with individuals trying to interfere with the process? And I assume this goes way beyond just the fact you have terrible internet out in the rules and don't have the ability to do that, or what have we seen in other states why this is necessary?
What we've seen in other states, and our guys have done a fair amount of looking at this, it has been different displays of crude things, as well as just other interruptions. The thing that spurred us on to this is that, I think you were in the IFC meeting where the nun was flashed up for a little while there, and we believe we have, I guess I should knock on wood, but we believe that we have, BPS has been able to actually figure out how to secure the system very much better. But I think it behooves us to try to deal with this by penalties as well, because technology, at least from my perspective, seems to keep developing, and perhaps I would say that hackers get better and better, at least from my perspective.
I appreciate that. One of the other issues I'm having a problem trying to do is pull up the votes for AB1 and AB2. The computer currently shows that 2 people voted yes on both of the bills and 40 people were vacant. So I guess it brings up some questions of our own technology problems. Thank you. Thank you, Madam Chair.
Okay, seeing no further questions from members of the committee, I thank you, Ms. Erdos, for your ability to answer our questions and walk us through Assembly Bill number 2. We will move to our public testimony portion of this bill hearing. For those of you who are following along with us online, this will relate to Assembly Bill number 2. There is on our agenda for the Committee of the Whole directions on how you can dial in to present testimony by phone. Once you dial in, you'll be entered into a queue. That queue will have other callers, of course, waiting to testify as well. Once you dial in, you must stay on the line until it is your time to speak. Otherwise, you will lose your place in the queue. Of course, because of time considerations, as I mentioned, each caller offering testimony during this period of public comment will be limited to not more than 2 minutes. The lines are now open for public testimony, and the committee will take the testimony first for those in favor, and then followed by those who oppose Assembly Bill 2, and then we will finish with those who are neutral on Assembly Bill number 2. If you are giving testimony via phone and you have some additional comments that you would like for the committee to consider, you may, of course, submit those in writing. As well, if you would rather give written comments in lieu of testifying over the phone, you may do so. All of those comments we would be happy to take, and there's an email address on the agenda as well for where you can submit your comments. For those of you wishing to testify on Assembly Bill number 2, we are going to turn it over to our Legislative Council Bureau broadcast staff, who have been able to do a great job of facilitating our public testimony. Please listen carefully to the instructions so that we know where to place you in terms of your testimony. And with that, we'll turn it over for public testimony for those in favor of Assembly Bill number 2.
Hello, Madam Chair. The line is open and working. However, the public comment queue is currently empty. There are no callers at this time.
Okay. With that, we will go ahead then and close public testimony, since we don't have anyone wishing to testify on Assembly Bill number 2. We will also close the hearing on Assembly Bill number 2. What is the pleasure of the committee? Senator Brooks.
I move that we do pass.
Is there a second? Senator Ratty? Any remarks on, you've heard the motion, any remarks on the motion? Seeing none, all those in favor, please signify by saying aye. Aye. All those opposed? If you are a nay, if you could please raise your hand so we can have a record of those nays. We have a nay from Senator Hansen, Senator Hammond, Senator Gogochea, Senator Settlemeyer, Senator Pickard. The motion carries. Assembly Bill number 2 will be reported do pass out of the Committee of the Whole to the Senate floor. We will move to the next item on our agenda, which is Senate Joint Resolution number 1, proposes to amend the Nevada Constitution to revise provisions governing the taxation of minerals extracted in this state. For members of the public who are following along, a copy of that should be available for you on the legislative website, and members of the committee have also received a written copy of that resolution, as it was just referred on the Senate floor to the Committee of the Whole. We will open up the hearing on Senate Joint Resolution number 1. We will first take testimony on this bill. Senator Brooks will be beginning with the presentation and will be assisted as well by Mr. Russell Ginden from our Fiscal Analysis Division and Mr. Brian Fernley from our Legal Division. And we will then take questions from members of the committee. I would remind members of the committee You will have one opportunity to go ahead and ask your questions before we move along to public testimony. With that, we will turn it over to Senator Brooks to begin with the presentation on Senate Joint Resolution Number 1. Senator Brooks, whenever you're ready.
Thank you, Madam Chair. Good afternoon, Madam Chair and Senate Committee of the Whole. My name is Senator Chris Brooks for the record. And this afternoon, I'll be presenting Senate Joint Resolution 1 to the committee. As Madam Chair stated, joining me will be our amazing legislative fiscal staff, Mr. Russell Gendon, and our legal staff, Mr. Brian Fernley, to answer questions as well. As we are all aware, the mining industry has enjoyed special treatment for their industry and the Nevada Constitution in one way or another for well over 100 years. This constitutional protection has led to a situation where the mining industry is currently highly profitable, and yet their effective tax rate to the state was only less than 1% last year, all while Nevada is experiencing the worst economic crisis in its history. Senate Joint Resolution 1 proposes to change that. This resolution proposes to change Article 10 of the Nevada Constitution. Under the Nevada Constitution, in Article 10, Section 5, the legislature must impose a tax upon the net proceeds of all minerals extracted in the state at a rate not to exceed 5% of the net proceeds, and the net proceeds are not subject to any other tax. Article 10, Section 1 of the Nevada Constitution also exempts mines and mining claims from the property tax. This resolution proposes to amend the Nevada Constitution to eliminate, 1, the requirements for the legislature to impose a tax upon the net proceeds of minerals extracted at a rate not to exceed 5% of the net proceeds, and 2, to eliminate the appropriation of a portion of those proceeds to each county in the state. Instead, this resolution would amend the Nevada Constitution to impose a tax on the gross proceeds of all minerals extracted in the state during a calendar year at a rate of 7.75% of the gross proceeds, and authorize the legislature to provide by law for the taxation of mines and mining claims and the proceeds of all minerals extracted in the state. Under this resolution, the tax on the gross proceeds of minerals extracted in the state would be imposed on minerals extracted during each calendar year beginning on or after January 1st, 2023. The amendment to the Nevada Constitution proposed by this resolution would also provide that a majority of the members elected to each house is necessary to pass any provision of a bill that enacts or amends a law providing for the taxation of mines, mining claims, or the proceeds of minerals extracted in the state in a manner that creates, generates, or increases any public revenue in any form. The amendment of the Nevada Constitution proposed by this resolution would also provide that an affirmative vote of not fewer than 2/3 of the members elected to each house is necessary to pass a bill to reduce the rate of or provide an exemption from the tax on the gross proceeds of minerals extracted by a particular class of taxpayers or imposed on a type of mineral extracted. Under the amendment to the Nevada Constitution proposed by this resolution, 50% of the proceeds of the tax on the gross proceeds of minerals extracted in this state would be required to be accounted for separately in the state treasury and used exclusively to fund a program to make payments to eligible persons domiciled in the state. The use of the remaining 50% of the proceeds of this tax would not be restricted by the provisions of the Nevada Constitution. If this resolution is passed during the 32nd special session of the legislature, it must also be passed by the next legislature and then approved and ratified by the voters in an election before the proposed amendments to the Nevada Constitution become effective. Mining is an important part of Nevada's history and heritage, and mining also plays a vital role in our state's economy, especially in rural Nevada. The methods of mining have changed and modernized over the years, and even the minerals that we mine are also changing. The way that Nevada taxes mining needs to change as well. And I would love to open myself up for any questions, as well as Mr. Gendon and Mr. Fernley.
Okay, thank you, Senator Brooks. What we will go ahead and do at this point is take questions from members of the committee and hopefully direct those questions to the appropriate individuals to help us better understand. We will begin the questioning with Senator Gogochian.
Thank you, Madam Chair. And I guess as I look at this and definitely understanding what the intent is, my concern is how would local governments apply a property tax rate? Again, that's exactly why we've had the net proceeds, and that's why it's structured how it is. There is, it's based on the load, technically the mineral load, and those land values, those values that are in that ore body. Now, explain to me how local government would approach this then. Clearly, they can come out and they are, the sales tax is there, property taxed on any fixtures that were on the property. But again, how do you value that mine property? And how do you assess a property tax rate to that?
I will begin with the answer, and then hopefully if Mr. Gendon or Mr. Fernley can fill in the blanks, that would be helpful. What this would do, it would turn over the ability to the Nevada Legislature to enable counties to assess those taxes. And I use an example of something that happened recently where counties got together and petitioned for the diesel fuel tax, and the Nevada Legislature allowed the counties to set that rate. And so that is what we would do if this were to be successful in the 2021 session. We would have to be setting those tax rates or on allowing the counties to set those tax rates.
If I may, Madam Chair, I appreciate that, but all counties are under the 364 cap. A number of these counties would be at that cap in some of the jurisdictions I represent. And again, you're missing the point. That's exactly why net proceeds is structured the way it is in the Constitution, because there was no mechanism to apply a value to that. If that's the case, then if we're going to do this, maybe I can go back in all my cultivated lands. I can just call it third-class grazing. You understand there is a difference in the values of these properties that are held in Nevada. And I'm really struggling with how the counties are going to be kept whole by, as I see the distribution. You've got to put something in here as well that allows for the property tax rate to be applied to a fixed value.
Senator Settlemeyer.
Thank you, Madam Chair. In reading this, it looks like it's applied to everything that has net proceeds of mines would become gross proceeds of mines. And if I'm reading that correctly, that applied to everything from copper, which has a very, very small margin of error, geothermal, gravel, lithium, which currently we're trying to develop those technologies even within major industry move to northern Nevada. Am I correct in that?
Senator Settlemeyer, except for, I believe, geothermal, which is treated as mining but not defined as mining in the Constitution, and so, but all the other minerals that you just mentioned would be covered. But I think it's important to note that the legislature would be able to exempt or lower any individual mineral or taxpayer class based upon circumstances that mineral or taxpayer class experiences.
I appreciate that. So then the legislature will have the full ability to pick winners and losers. With that being said, is there any other industries that are taxed on their gross in the state of Nevada?
Mr. Gendon, could you answer that question, please?
Yes, Senator Brooks. For the record, Russell Gendon, Principal Deputy Fiscal Analyst with the Fiscal Analysis Division of the Legislative Council Bureau. The most probably obvious one that everybody would be familiar with is the gaming industry has the tax that they pay monthly based on their monthly gross gaming revenue. There's the commerce tax that was approved in the 2015 session that taxes the gross revenues of businesses. And that one is very broad-based in terms of all the types of businesses that are in it. It has actually 26 different tax categories in terms of the type of business and the rate would be assessed. but that is on gross revenue. It just doesn't kick in unless you have more than $4 million in gross revenue in a fiscal year tax period. And so those are the ones that come to mind that are taxes on the business from in a sense, a gross revenue point of view. You have other types of taxes that are imposed on the value of, or in a sense, the gross revenue that the business is getting from their activity, such as, for instance, the transportation connection tax that is sometimes referred to as the Uber and Lyft tax, the 3% tax that was put in place not too many sessions ago. But again, that one is passed on to the consumer and the value. So you can see where it gets tricky. But I would argue probably the commerce tax and the gaming tax are the two obvious ones that are on gross revenue of the operations of the business.
If I could follow up on that, Mr. Ginnon, I thought that gaming was actually based upon the win, not on the concept of the gross. And I thought also they could, actually deduct their MBT, modified business tax, and things like that off of the commerce tax. Or am I incorrect?
The way the tax works, the win is their gross revenue. And so what the win is it's what the house keeps from the wagering that's occurring on the electronic gaming device or the table games. There are adjustments made for the tax due to credit play. That credit is not taxable until it's actually collected, which makes sense from a taxation point of view. But no, there are no adjustments for expenses against the gaming percentage fee tax. There's adjustments for credit play in terms of determining what's called taxable gaming revenue, but the starting point is their gross gaming revenue, which is what they receive from their winnings of the gambling activity each month.
Okay. Thank you. Thank you, Madam Chair.
Senator Hansen.
Thank you, Madam Chair. A whole series of questions. The first one, how is this related to COVID? I'd like to ask the bill sponsor. I mean, this is supposed to be a special session based on extraordinary circumstances, according to the Constitution, and I'm not aware of anything here that has anything to do with anything that's related to COVID or special, that we have to do this in a special session to ramrod this through. Could the bill sponsor please address the urgency?
All I would state is that resolutions aren't included in proclamations for special sessions.
Okay, I guess the answer then is there is no urgency. It's simply a matter of convenience. So, Madam Chair, I would just object that this is not appropriate to bring up at this point in the session. Next question, though, is it appears that by the way, we just got this dropped in our lap literally, an hour ago, for a major, major change in the Constitution. Tax structures, this just, so you know, Mr. Sponsor, this will kill rural Nevada and kill rural governments. As my brief 30 minutes of reading of this thing, it is the death knell for rural Nevada. Having said that, I want to know, though, we're also putting in this a constitutional provision which apparently removes the Gibbons tax restraint provision. So now we're going to actually inverse it. So instead of requiring a 2/3 vote for a tax increase, we're now going to make it a 2/3 vote to remove a tax increase. Am I reading that correctly?
Specific to this bill or this resolution on this specific industry, it would require a 2/3 majority vote to lower or exempt what would be the default tax rate.
Thank you, Madam Chair. Do we have anybody from legal who can answer the question? It seems we have two conflicting potential. If this passes, it would be in conflict with the Gibbons tax restraint initiative. Am I understanding that correctly? I mean, how would this take precedence over that?
I do believe we should have Mr. Fernley available to answer that particular question.
Yes, for the record, this is Brian Fernley, Legislative Counsel. The rule of construction that would apply in that case is that the provision that would allow the tax on the gross proceeds of minerals that is set forth in this joint resolution would be a more specific and a more recently enacted provision. So it would prevail over the other provision requiring a 2/3 generally for bills that create, generate, or increase public revenue.
Okay, well, thank you for that explanation. I just object to the whole process, Madam Chair. I think this is just absolutely outrageous to do this in a special session.
Senator Keykever.
Thank you, Madam Chair. I think for Mr. Gindin, is it possible under the gross tax scenario we're envisioning that a 7.75% levy on gross revenue could exceed sort of pre-tax profit for small mining companies?
All right. Again, for the record, Russell Gindin, Principal Deputy Fiscal Analyst Division, and I need to sort of think through that, because I think what you're asking me is, could have they had a net profit or net income, but for having to pay the gross tax? Is that sort of the question?
Right. Could we be taxing them into unprofitability?
That's a very difficult question for me to answer, but I guess the honest answer would be, is it possible? Yes, that because based on the calendar year 2019 actual data of the 104 mines that were filed reports, I think somewhere around 40 of them, their deductions that are allowed under current law were greater than their gross proceeds. So that means they didn't pay any tax because they're deductions. So now if you move it over to the gross side, then they would obviously pay tax because it's not dependent on the net. And so if their expenses already were greater than their revenue, then this would compound that, I guess, is the only way that I can answer that question, Senator, that there could be situations where this tax could put the viability of a business in play. But that could be said for possibly any tax that might be imposed upon a business, because it would be an expense that they would have to deal with at their margin to the extent they could pass it on to their customers or not through, price mechanisms.
Not as easy with a commodity. Thank you, Mr. Gindin. I appreciate that. And I guess one more question, Madam Chair, for I guess Mr. Brooks. I've objected for many years to fixing tax policy in the state constitution and providing broad discretion to the legislature as an entity that should have the authority to set tax policy for our state. So I guess the question is, why do you want to continue having industry-specific tax policy in the Constitution, and why a gross revenue tax rather than a severance tax or some other taxing mechanism that could be used?
Well, thank you, Senator Keykefer. I think it's important to note, going back to your first question, that that was contemplated when we looked at having the ability to exempt or lower tax rate based on the operating circumstances of a mineral or a mine, and so that very scenario that you just described doesn't take place. And as far as why would this be a constitutional change as opposed to whatever else, I guess, we using the same protections that have existed for mining for many generations, we wanted to change that paradigm so that it created it would motivate those, or not motivate, it would require those mines to pay a minimum based upon the ability of the legislature to set what that minimum was, as opposed to being capped and our hands kind of tied by the Constitution. So we believe there's enough flexibility in the proposed amendment that it would allow the legislature to have full ability to regulate what that rate was and how it was applied.
Senator Hardy.
Thank you, Madam Chair. If I could just make the observation that businesses like stability, so mines that are currently able to stay open are staying open. This obviously would put them in a different position. My question comes with Mr. Fernley, perhaps, can answer the phrase used exclusively to fund a program to make payments to eligible persons domiciled in this state. Are there not people domiciled in another state that we have an obligation financially for, and this would put that at risk and put that in the Constitution? And is this a program, or is this any program? Is that legalese for a meaning any, and eligible persons have to be domiciled in this state in order to be able to use the money produced by this tax in order to pay them?
Again, this is Brian Fernley, Legislative Counsel. I think it's important to note that this provision of the Constitution would require the legislature to establish the program. So it would be the program would be established by the legislature with eligibility criteria established by the legislature. The one restriction on that would be that the payments would have to be to persons domiciled in Nevada. That would essentially mean somebody who had a residence in Nevada, and that was the residence that they returned to and kept as their residence. So there would be discretion in the legislature to establish this program and the criteria for qualifying to receive a payment pursuant to the program.
This would be a naive follow-up question then. What is the program that we're envisioning that would be funded by this tax then?
Again, this is Brian Fernley, Legislative Counsel. It would be a program that would need to be established by a future legislature after the Constitution, or it could be established by the legislature in a companion bill to this constitutional amendment, or it could be established by a future legislature after the constitutional amendment became effective.
So this may be a question for Russell. The program takes that much money that we're currently getting in or anticipating getting in that one program would take?
For the record, Russell Ginnen, Principal Deputy with the Fiscal Analysis Division. I don't know how to answer that question because I think, as Mr. Fernley explained, it would be up for the legislature to then provide for what program would be these funds that are earmarked, the 50% portion would go to. So, going to the residents, it would seem to me to be they would have to create a construct where the amount of money that comes from the 50% and would be allocated out to what the legislature decides to be the eligible persons. So I know I'm not answering a question. I just don't know how to answer the program because that will be determined by the legislature.
So let me put it this way then. How much money are we looking at that this tax would bring in on your current tax sheets that you've got and you are looking at all of these mines? How much money are we talking about that we would have in play to use for a program?
If you, again, using the calendar year 2019 actual data reported by the mining operations to the Department of Taxation, and so again, as sort of the discussion was during the 31st special session, using that in a static analysis that had this 7.75% tax and gross proceeds been in place, it would have generated approximately $607 million. So splitting 50%, and then if you hold the amount that was distributed to the local governments, and as well as the school districts and the state debt rate harmless, then that would have left $541 million of that 606 available to be split 50-50 between the general fund and this other fund for the program to be established by the legislature. So 50% of that 541 would have been approximately $271 million that had it been in place in calendar year 2019, and based on the gross proceeds of approximately $7.8 billion, that would have been the $271 million. That would have been the 50% portion that would have gone to this fund to be allocated out to the eligible persons as determined by the legislature.
So that 270 million would be done away with the current net proceeds. So minus the net proceeds, how much would we have? Or does this actually get rid of the net proceeds?
No, then what would happen, this would be the 50% portion that would go to that's earmarked to this fund, that then the legislature can establish the program to allocate to eligible persons. So then the other 50% would go to the general fund. So that other 271 million would have gone to the general fund, but because we actually got about $57 million under the current law, then the net increase to the general fund would have been about $213 million had this been in place in for calendar year 2019 for FY 2020 taxes. So again, the general fund increase in revenues from minerals would have been approximately that $213 million over what we currently received under current law.
And how much do we pay now in Medicaid?
I don't know the answer to that, being, again, more your revenue guy, not the expense guy.
So I'm looking at what big program we could use to put in $270 million in. That would be a program. Do you have a program that uses that much right now?
There's several programs that are part of the budget, because you have the K-12 education, you have any program that you could decide that the legislature would decide where they would want to allocate the additional funds. And given that the current budget is probably prior to the virus impact was around $4.6 billion. So clearly you have programs within that you could give this to, or new programs for that matter.
Appreciate it. Thank you.
Senator Severs-Gansert.
Thank you, Madam Chair. I have some fiscal questions too. I'm trying to figure this out. So Russell, I think what you just said, well, maybe I'll go broadly. I think you said that there's 104 mining companies now basically on our sheets paying taxes, and there's 40 of them whose deductions exceed their, or their expenses exceed their revenue. So potentially this could put them out of business because they don't make a profit right now, is what it sounded like. And then so there's 40 of those. How many more are there that are within 7.75% of making a profit? So by requiring the 7.75, you just increase their expenses 7.75% of their gross. So how many are within that range as well?
I do not know the answer to that question. I haven't done the analysis. I just trying to quickly here today look at some of the data. Could go see that based on the calendar year 2019 data, there's approximately 40 mining operations that had zero net proceeds, which means that their deductions were at least equal to or greater than their gross proceeds. Thus, they did not pay any mining tax. So then is what you're asking, well, clearly there's some where they may have had net proceeds that were positive, but they weren't that much. And I know this is semantics, but using the word profit, there may be one and the same, but I can't necessarily use that word here. This is net proceeds. So these expenses here that are allowed under current statute to determine net proceeds, I don't know that those are all the same expenses that a mining company gets for reporting, quote unquote, their income to the U.S. Government for income tax purposes, or what they would do from an accounting point of view to determine profits. And I know that's being like technically, but correct here, but I just want to say that I'm talking here about what is a net proceeds concept, which is the statutorily allowed deductions less of gross proceeds. But clearly, if that is negative, if there's additional expenses that they would deduct that aren't allowed under the net proceeds, then that would just exacerbate the how much expenses could be over what they actually receive for selling the mineral that they're extracting.
Thank you. And then I wanted to understand the numbers a little bit better. So it sounded like this potentially would produce $606 million, and then you talked about the hold harmless. So it sounded like the total that the state's receiving for both local and general fund right now is about $114 million a year, and that would grow to over $600 million a year. Is that correct?
Well, in FY20 here, based on the actual stuff for calendar year 2019, the state received approximately $57 million in general fund revenue from the net proceeds of minerals tax. And so that's when I did the delta of the 50% of the net after covering the local governments and school districts and the state debt rate portion. That was the $541 million. And so splitting that 50%, that was $270 million that would go to the general fund, which would only be an additional increment of about $213 million because, we already get $57 million under current law.
Okay, so we get 57, we'd be adding 213, but I never quite understood when my colleague asked the question about the local government. So this isn't really set up to be a split with local governments at all. It would be sent to the legislature, and then the legislature would set up how taxes, 50% of the taxes would be divided up, or how do you talked about a hold harmless for local governments, but I don't think that's in this bill at all.
You're correct, Senator, that the way I look at this is, and as I think was testified to, that this is removing the provisions in the Constitution with regards to the local portion. But as was stated, that would be up to the legislature to decide what to do with regards to the amount of proceeds that local governments well, the better way to say it, those entities that currently have a property tax rate that is attached to the net proceeds under the current constitutional and statutory construct, what the legislature is do that. So I apologize. That was my decision to staff when I was doing this, to just say, well, let's do the scenario that it would generate approximately $607 million. 7.75% rate against the gross of $7.8 billion had it been in place in calendar 2019. Thus, I also said, well, what would be the net amount that would be available if the legislature made that decision to hold all the entities harmless from what they got in FY 2020 based on calendar year 2019. So that's me doing that math. But again, it would be up to the legislature if this became constitutional law of what to do with regards to the amount of the proceeds that would come from the tax on gross proceeds to be distributed or allocated in some mechanism to the local governments.
Thank you. So there's no guarantee that local governments would get any money with this bill or this resolution?
Not the way I read it in terms of the constitutional provisions. It would be up to the legislature to make that decision to take some of the proceeds from the tax on gross proceeds, deciding to provide that to the local governments that were getting money previously under the net proceeds concept.
Thank you.
Senator Pickard.
Thank you, Madam Chair. Just two quick questions. I think first to Mr. Brooks, you suggested that we could, after this was enacted, make adjustments to exempt or reduce that with a 2/3 vote. Is that correct?
That is correct.
Okay, so that presupposes then that the year before or the biennium before the legislature made that decision, those mines would be subject to the tax as is before any reduction. Is that a fair statement?
Senator Pickard, not necessarily. The legislature has the ability, and I'll use the example of, let's say, 2021 legislative session, that they could put in place legislation that in the event of the passage of this, certain things would happen, and those certain things could be how we treat the local tax, the local contribution, and which exemptions and reductions could be applied before that tax is actually applied.
Okay, I think I understand then, but that would require a 2/3 vote, correct?
Senator Pickard, yes, sir, it would.
Okay, thank you. And Mr. Gindin, just a quick question. Of the 40 mines that would be put out of business, how many, or that could be put out of business, that are the ones that you said currently have expenses greater than their gross revenues, can you tell me how many people, how many Nevadans are employed by those 40 mines?
For the record, Russell Gindin, Principal Deputy. No, I don't have that information. All that information is not part of what's reported in the Net Proceeds Minerals Bulletin published by the Department of Taxation.
All right, thank you. And thank you, Madam Chair.
Okay, seeing no further questions from members of the committee, I will thank Senator Brooks, Mr. Gindin, and Mr. Friendly for being with us and being able to answer all of our questions and walking us through the bill. I appreciate it very much. At this point in time, we are going to move to our public testimony on Senate Joint Resolution number 1. We will first take public testimony in favor of Senate Joint Resolution number 1. We will then take public testimony in opposition to Senate Joint Resolution number 1. And finally, testimony in neutral on Senate Joint Resolution number 1. Under this item, public testimony can be presented by phone. Again, please refer to our committee agenda for directions on how to dial in. Once you dial in, you will be entered into a queue of other callers who are waiting to testify. I would remind everyone that you must stay on the line until it is your time to speak. Otherwise, you will lose your place in the queue. Because of time considerations, we will, as we have been, giving each caller offering testimony during this period of public comment, a limit of 2 minutes for that testimony. Once you get to that 2 minutes, I will pop in and politely remind you to wrap up your testimony so that we can continue to hear from others. Also, at this point in time, because of time considerations, we will be limiting testimony in support to 30 minutes, testimony in opposition to 30 minutes, and testimony in neutral to 30 minutes. For anyone who is not able to make it onto the line to give us your public testimony, we, of course, will always take that in written form as well. And anyone who has additional testimony over the 2 minutes may also submit that in writing, as well as anybody who simply would rather give in writing written testimony, rather than giving public testimony over the telephone. If you are wishing to give written comments, there is an email address on our agenda as well where you can submit those written comments. At this point in time, we are going to turn it over to our Legislative Council Bureau broadcast staff, who has been doing a wonderful job of keeping our public testimony moving quite along. And we will again begin with those who are in favor of the bill, of the resolution. And with that, please take careful consideration to listen to the instructions so that we can call you in the appropriate order.
If you are in favor of the bill, please press star 9 now to get your place in the queue. I repeat, if you are in favor, please press star 9 now. Madam Chair, there appears to be no proponents.
Okay. We will move to those then who are in opposition to Senate Joint Resolution number 1. Please, again, listen carefully to the instructions so that we can have you in the appropriate place. If you're in opposition to Senate Joint Resolution number 1, we will go ahead and take your testimony now.
If you are in opposition to Senate Joint Resolution number 1, please press star 9 now to get your place in the queue, and we will call you in order. Caller with the last 3 digits, 792, please slowly state and spell your name for the record You have 2 minutes and may begin.
This is Patrick Donnelly, PatrickDonnelly. I'm Nevada State Director with the Center for Biological Diversity. While we applaud the legislature being willing to finally address mining taxes, and we support the Assembly Bill AJR 1, we must oppose SJR 1 in the strongest of possible terms. Creating a dividend program where the mining industry is making cash payments to Nevadans will create a host of perverse incentives and will ultimately create a situation of nearly unlimited political influence for the mining industry. Mining is incredibly destructive for our environment. Some mines in Nevada permanently poison the groundwater around them, like forever, as we have out there in Yerington. Mines also result in a habitat loss for wildlife. These impacts need to be regulated and ameliorated to ensure mining does not unduly impact our state's ecosystem. Nevadans directly and personally financially benefiting from the mining industry will create a perverse incentive for the state and the residents here to promote the most expedient and cheapest mechanisms of permitting new mining projects. You could actually potentially put a per person dollar amount on any new mining project, setting up what's effectively a legal bribe of the populace to facilitate unhindered mining and potentially strip away current environmental protections which the mining industry might deem too restrictive. Further, we really need to have some perspective here. Our back-of-the-envelope calculation that shows that under SJR 1, every Nevadan might get $150 or up to $200 a year. And while I won't belittle the value of that to people who are struggling, that's not going to be the difference between poverty or not poverty. That won't cover a month's rent. And for many of us, frankly, we'll fritter it away on dinner and drinks. Whereas collectively, that $300 million could go an incredibly long way toward filling our woefully inadequate education budget or providing health care for low-income individuals. That $300 million is far more valuable to us collectively as a society than it is doled out to individuals. And we will fight hard to see AJR 1 passed into law by the voters, but we must oppose SJR 1. Creating a mining dividend creates perverse incentives and will prevent future badly needed environmental reforms of the mining industry. Thank you.
Caller with the last 3 digits, 863. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, good evening. This is Dagny Stapleton, representing NACO, Nevada Association of Counties. Our opposition is based specifically on Section 5.2. Removal of the language in that section would eliminate the portion of net proceeds that go to Nevada's counties, as the committee has also already discussed. We appreciate Senator Brooks' statement that counties could be enabled to raise revenue if this section was removed. However, we did want to get on the record that that currently doesn't provide any guarantee that that could happen. Perhaps we would be able to work on companion legislation if this moved forward that could provide that substitute for the loss of local revenue. Counties currently, like the state, have seen a significant reduction in county revenue, including seat tax and property taxes. So a reduction specifically for the rural counties that this would impact, a reduction in net proceeds could really have an adverse impact on the broad range of critical county services that those counties provide. As an example, that includes emergency response, our local court systems, human services, and elections. Just 2 examples I want to provide. In Humboldt County, which actually does have a relatively diverse economy, but of which mining is an important piece, their net proceeds in 2019 were over 25% of the total revenues that that county received. And of that, 16% of those revenues went to their general fund. So that would be a really dramatic reduction for them. And in Elko County, for example, net proceeds to their county fire district, so that's their local fire response, net proceeds makes up 17% of that budget. So NACO opposes any decreases to county revenues, especially during a time when county revenues overall have already been significantly reduced so much.
Caller with the last 3 digits, 863. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good afternoon. My name is Dr. David Jensen, Jensen. I'm Superintendent of Schools for Humboldt County School District. First, I appreciate the opportunity to address the members of the Senate and the comments that have been provided so far. As noted, I am in opposition to this bill. The concern that I need to express is that there has been insufficient opportunity for districts and local governments to take a look and to provide a fiscal analysis. One of the issues that I think we're clearly aware of is currently gold is sitting at record highs. However, as we are reminded, I think back to 1999, where gold prices fell within the $300 range, gold is a moving target. So as we identify specific levels of revenue, it's inaccurate to think that we're going to be able to generate $600 million annually. That could change dramatically based upon international economic climate. The other issue that I need to express is that we need to be reminded that these are fixed resources. There's only so much gold. And so as a result, at some point, those resources will diminish and go away. It's the basis of net proceeds of minerals for school districts at this time, so that those can be set aside to offset future deficits. Finally, the last two things that I need to identify are the unaddressed components of this bill, and those are identifying what are the groups that would benefit from this. Listing those as unidentified becomes hard to support, and then the making notation of the potential of a hold harmless. Again, I truly appreciate noting the potential of that, but as has already been noted, it is not included in the bill, so it becomes a presumption and not a true opportunity. Again, I am in opposition to this, and I would ask that this bill not move forward. Thank you very much.
Caller with the last three digits, 580. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening, Madam Chair, members of the Senate. For the record, I'm Paul Enos, P-A-U-L-E-N-O-S. I am the CEO of the Nevada Trucking Association, and we are opposing SJR1. Not only is this going to have a direct impact on the mining industry and the miners who, are some of the best taken care of employees in the state when you look at their compensation. And I speak to that from a personal experience. I worked in a mine. My father was a gold miner for 36 years. I grew up in Elko. The mining industry is one of the most responsible, community-oriented industries I've come in contact with this state. Not only are it going to affect the miners, it's going to have a detrimental impact on all of those other businesses that rely on the mine as their customer, including my trucking company that move a tremendous amount of ore from the mines to the mills to the processing facilities. This would have a detrimental impact on them, on the motels, on the hotels, on the restaurants, on all the retail businesses in rural Nevada. This is really going to be the death knell of a lot of those communities, especially on the I-80 corridor, if this moves forward. I've seen what's happened when the price of gold has dropped down, as Dr. Jensen said, once again, from a personal experience. My father was at Newmont Mining on the Carlin Trend for 27 years. When gold got too expensive to produce and make a profit here in Nevada, he went to Indonesia. All the exploration went to Indonesia, went to Ghana, went to Uzbekistan, went to South Africa, went to Australia. Just because the gold is here in Nevada doesn't mean that those mining companies need to operate here. They're going to look elsewhere if it doesn't make sense for them to make a profit and take care of their employees and drive the tremendous amount of economic activity that they do in the state. Thank you.
Caller with the last three digits, 080. Please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller with the last three digits, 080. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Susan Fisher, S-U-S-A-N-F-I-S-H-E-R, with Donald Carano, speaking on behalf of Nevada Mineral Exploration Coalition. The NMEC, Nevada Mineral Exploration Coalition, has already been severely impacted by the current pandemic. They depend on financing that comes in from international organizations to finance exploration projects here in Nevada. And a lot of that has dried up. There is some activity, of course, still going on, but it's significantly reduced. This creates even more of an uncertain financial market and will stop those dollars even more. and these create hundreds, if not thousands, of jobs in Nevada. I would also like to put on the record on behalf of CYRQ Energy, that's CYRQ Energy. We oppose SJR1 as well. This is a geothermal company. We have geothermal operations in Nevada in partnership with Ormat in Churchill County, and also operations in the Reno area. This is going to have a significant impact on their operations as well, and they had planned some expansion in the Reno area for space heating and water heating, and this could certainly impact that. So we urge you not to support SJR1. Thank you.
Caller with the last three digits, 351. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Paul Morakan, Moradkhan. Good evening. Paul Morakan, Senior Vice President of Government Affairs with the Vegas Chamber. In regards to SJR1, the Vegas Chamber is in opposition to this resolution. This is an industry-specific tax, and we've learned several times over the last 2 decades that relying on a specific industry taxation makes our tax base more vulnerable and less diverse. This is a significant tax increase on a specific industry, and we urge you not to pass this during this economic and public health crisis. We also believe that if this resolution is passed, that good-paying jobs in the industry will be lost, and that will directly impact Nevada families in those communities that need those jobs, especially in our rural communities. We are concerned about those employees and their families if those jobs are lost. It will also negatively impact several counties and local governments in those areas and impact their residents as well. We're also opposed to the concept in the resolution requiring that any lowering of a tax rate will require 2/3 vote by this body. This is an unprecedented change in tax policy, which could potentially harm all Nevada business in the future. During this economic crisis, we cannot stress enough that employers need support, and this type of tax policy will have the opposite effect. Sustainable taxation should be broad-based so the burden is fairly shared, and industry-specific taxation supports vitality in the system. We at the Vegas Chamber support the important services, of course, in the state, such as education and healthcare, but we do believe that this is not the right approach, and we ask for your opposition on this resolution. Thank you very much.
We are still in opposition of SJR1. If you would like to give testimony in opposition, please press *9 now to get your place in the queue. Caller with the last three digits, 884. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening. For the record, this is Andrew McKay, ANDREW. MACKAY. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. We rise in opposition to this matter, very similar to what many of the previous speakers made, but would like to put on the record the fact that we have serious concerns due to the fact that this will impact businesses that serve the mines and the employees. Many of our members not only provide services to the employees of the mines, but to the mines themselves. And the policies that would be enacted pursuant to SJR1, we have grave concerns that will have a detrimental impact on our rural auto dealers in Elko and in Winnemucca, and then in other areas of the state. So we urge opposition of the body to this matter, and we thank you for allowing us the opportunity to speak on it.
Caller with the last three digits, 738. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good afternoon. This is Tyree Gray, TYREGRAY, President of the Nevada Mining Association. Since the inception of Nevada, the mining industry has been a great partner of Nevada's. In every economic downturn, including this one, the mining industry has been here for the people of Nevada to help the state get through the other side. Though SJR1 is presented as a tax increase, it is in fact a death sentence for Nevada's mining industry. As Mr. Ginden stated, there are at least 40 mines across the state that are not profitable. There are dozens of others who, with the passage of SJR1, will be put in the same exact position. Further, as Mr. Ginden points out, not all expenses that are incurred by a mining operator are deductible under the net proceeds of minerals. Therefore, even the deducted amounts do not actually account for the true cost of mining operations in Nevada. It is well known that the mining industry accounts for over 30,000 jobs, both direct and induced. These are highly compensated employees spread throughout the state, with many in rural communities where the mine is the major employer, major contributor of taxes, and the key partner of education. What happens to these people? Do they just shift from the mine rolls to the state unemployment rolls? What happens to these communities? Do they lose their financial independence and look to Clark County and Washoe County for supplementation of these lost revenues? More importantly, what happens to the children and their education? The mining industry is here for Nevada. We have been at the table and we have been willing to discuss and figure out how we can best help. But this is not the vehicle. SJR1 is bad for Nevada. Thank you.
Caller with the last three digits, 964. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Mary Walker. I represent Lyon County, and we are in opposition to SJR1. We are very concerned about the loss of very good paying jobs, which the mining companies do provide. We're concerned about the rural economy if mining is taking a devastating hit. But something you need to take a look at is the mining companies pay a huge amount of sales tax on their equipment, primarily out-of-state sales. That's the mining companies that are buying huge pieces of equipment from different states. And when it comes into this state, then it's taxed, and it goes into the consolidated tax for local government, and it is split statewide. Clark County receives those. Clark County, Las Vegas, Henderson, Reno, Washoe County, they get a portion of that out-of-state sales tax from mining, and it's fairly significant. Particularly, it's important because when mining is doing good, it means the rest of the economy is not doing good typically. And in a recession, it's one of the bright lights that we have to carry us through. We do appreciate very much Senator Brooks' comment that he would look towards trying to replace any money that the local governments would lose, and we would sincerely appreciate working on that if this bill does go through. But I think an analysis of how this the mines will not be able to buy those big pieces of equipment and that sales tax that goes statewide, I think an analysis needs to be done that how much of the loss of revenue is Clark and Washoe and everybody else in the state going to have. So thank you very much for listening. I very much appreciate everything that all of you are doing in the Senate, and I wish you well. Thank you very much.
Any more callers wishing to give opposition for SJR1, please press *9 now. Caller with the last three digits, 152, please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is James Wadhams, Wadhams. I'm an attorney in Las Vegas with Black & Wadhams, and I'm calling on behalf of Newmont Mining Company, who has operated on the Carlin Trend for a number of decades, is currently a partner in the joint venture of Nevada Gold Mines. I speak solely on behalf of Newmont. Over the years that I've been involved, mining has always responded when requested. This particular bill, we believe, is placed at a level that will make mining unsustainable. And the difficulty with that is that the anticipated income will probably not, in fact, may well not even meet the expectation and may, frankly, make the industry itself unsustainable. We have concerns about the language and the provisions in the bill otherwise, but I think the more important piece is as we are coming out of a crisis in which the economy has suffered greatly because of the major shutdown of the primary industry in this state. It suggests that perhaps as we look for revenue sources, we should look at diversifying rather than being dependent upon single sources. The difficulty presented by this particular bill is it takes the one source that may be somewhat counter-cyclical and may put it out of business, so we lose that other point in making our tax base more diversified. I thank you for your time and attention and urge you to vote no on this resolution.
Madam Chair, there is no more opposition testimony for SJR 1.
Great, thank you. We will then move to those wishing to testify in the neutral position on Senate Joint Resolution number 1. If you are wishing to testify neutral, we will take your testimony now, and please listen carefully to the instructions so that we can get you heard before the committee.
If you wish to testify neutral on SJR 1, please press *9 now, and we will get you in the queue and call you in order. Caller with the last 3 digits, 898, please slowly state and spell your name for the record. You have 2 minutes and may begin.
For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. I'm here in the neutral position today. As a native Nevadan, I believe that all revenue options are critical for our state to consider and have on the table. However, we are concerned about the environmental impacts this may have on our state, as we have seen a history in Alaska that has shown abuse in a system similar to this. We thank you for keeping revenue options open, and we would like to have further conversations about this bill and AJR 1, which we currently prefer. We all agree mining must pay their fair share, especially at a time when they are doing better than ever, and that corporate welfare should not be allowed in our state in any form. We appreciate the efforts on this bill, and we look forward to further discussions. Thank you.
Caller with the last 3 digits, 732, please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Kyle Davis, K-Y-L-E. DAVIS, and I'm here today on behalf of the Nevada Conservation League. The Nevada Conservation League is neutral on SJR 1 in its current form. We appreciate the efforts of the body to find additional revenue during these tough budget times for our state. However, we are concerned that SJR 1 contains problematic provisions that could hinder Nevada's ability to protect our environment. Other revenue proposals aimed at mining considered by this body have not contained similar proposals. Many other states, especially in the West, have state budgets that are dependent on oil and gas extraction. Alaska has a mechanism similar to the one contemplated in SJR 1 that provides payments directly to Alaskans. Essentially, these provisions make a state and its residents naturally in favor of increased resource extraction, no matter the environmental consequences. We're concerned about the creation of a fund that does not help the state fund crucial programs, but instead creates a program that incentivizes resource extraction, no matter the environmental and social costs. That being said, we do support the goal of increased revenue from the mining industry to better account for the value of the natural resources that they take from our state. Our state currently spends less than 1% of our general fund on conservation and environmental protection, and increased revenues from mining could help remedy this situation. We welcome the opportunity to continue to work with the legislature to craft legislation that better meets these goals. Thank you.
Any more testifiers wishing to testify in neutral, please press *9 now. Madam Chair, that concludes public testimony on SJR 1.
Great, thank you so much, and thank you for, of course, helping us with public testimony. We appreciate it, and thank you for everyone who called in to give their public testimony. With that, we will go ahead and close the hearing on Senate Joint Resolution number 1. What is the pleasure of the committee? Senator Brooks.
Thank you, Madam Chair. I move we do pass.
Is there a second? Senator Kinsella. Any discussion on the motion? Seeing none, all those, oh, sorry, I apologize. Senator Hansen was moving a little too fast for you. Senator Hansen, please.
Thank you. Real quickly, Madam Chair. I just want to get on the record that I don't think you meant to intentionally, but the LCB staff, Mr. Ginden, indicated that the gross gaming tax is, in fact, a gross tax. But as he then pointed out later, he pointed out that it was a winning portion. It wasn't based on the gross. So I just think we need to make sure that's clear on the record. Gaming does not pay on their gross. They pay on their net. Thank you.
Any further discussion on the motion from the committee? Seeing none, all those in favor, please signify by saying aye. Aye. Any opposed? If you are a nay, if you could please raise your hand so we can have a proper record of that. Senator Hansen, Senator Gokachia, Senator Hardy, Senator Settlemeyer, Senator Hammond, Senator Gansert, Senator Keykever. Motion carries. Senate Joint Resolution number 1 will be reported to the floor of the Senate. We will be in just a brief 1-minute recess. The Committee of the Whole will come back to order. Members of the committee, we will move on to the third bill on our agenda at this point in time, which is Assembly Bill number 1, ratifies certain technical corrections made to NRS and statutes of Nevada. For those of you who are with us participating remotely online, that is available for you. And then, of course, the committee members did receive a copy of that as well. At this point in time, we will go ahead and proceed with the testimony on this particular bill. Then, of course, we will take questions from members of the committee. Members of the committee will do one round of questions for everyone, so make sure you have those in order. And then we will go ahead and proceed with public testimony on Assembly Bill number 1. We should have with us to help walk us through and answer any questions on Assembly Bill number 1, our legal counsel, Mr. Brian Fernley. And so whenever he is ready to join us, he will be joining us remotely, and we'll let him proceed as soon as he is connected and ready.
Thank you, Madam Chair. This is Brian Fernley, Legislative Counsel. I'm here to present Assembly Bill 1 to the committee. And to begin, as background, after every legislative session, the legal division of the Legislative Counsel Bureau undertakes a project of codifying the bills that were enacted and approved by the governor during the legislative session. We undertake the process of codifying them into the Nevada revised statutes with the goal of providing an easy to access and easy to understand compilation of the statutory law of the state of Nevada. In conducting that process, sometimes it becomes necessary to correct technical errors, clerical errors, typographical errors that are found in the bills that were passed and approved by the governor during the legislative session. This bill before you today asks the legislature to ratify some of the technical corrections that were made during the codification of the bills that were enacted during the 2019 legislative session. And if it's all right with the chair, I will walk through each of the bills that were corrected and how, in the manner in which those technical corrections were made. The first bill that was for which errors were corrected was Assembly Bill 431. Assembly Bill 431 revised the right to vote of convicted persons so that any convicted person who is not incarcerated, including those persons who are placed on probation, granted parole, granted a pardon, or released from prison after completing a sentence of imprisonment, were immediately restored to the right to vote. The bill inadvertently failed to include this restoration of the right to vote in the correct section of the Nevada revised statutes. To correct this clerical error and ensure that the intended persons were restored to the right to vote, NRS 213.157 was codified to clarify that a person who is placed on probation, granted parole, or granted a pardon is immediately restored to the right to vote. So that this section is consistent with the other provisions of the bill. NRS 293.540 also was codified to make it clear that a person's right to vote may only be suspended if the person is incarcerated. Section 7 of AB 431, which is contained as a reviser's note in the Nevada revised statutes, was codified to clarify that any person convicted before the effective date of the bill who is not incarcerated and has not already had his or her right to vote restored is also restored to the right to vote. The next bill where the technical correction was made is Senate Bill 151. Section 1.7 of Senate Bill 151 increased the period for a tenant to take action after receiving a notice to pay rent or surrender the premises from noon on the 5th full day to before the close of business of the court on the 7th judicial day. Sections 1 and 1.7 maintained this time period for tenants of commercial premises, but SB 151 inadvertently failed to amend NRS 40.2512 accordingly to account for the changes to the for residential tenants. To correct this technical error, Section 4 of the bill amends NRS 40.2512 to include the applicable periods within which a tenant who is in default in the payment of rent is required to pay the required rent or surrender the premises. The final bill for which a technical correction was made is Senate Bill 161. Senate Bill 161 exempted internet lenders that make loans exclusively through the internet from certain requirements related to maintaining a licensed office or place of business in Nevada. and prohibitions on conducting the business of making loans in the same office or place of business at which other types of business are conducted. These sections of SB 161 inadvertently excluded the word business and thus failed to refer to an internet business lender that makes business loans exclusively through the internet. To correct this typographical error, sections 5 through 7 of the bill amend the relevant sections of SB 161 to use the term internet business lender and to define the term internet business lender to mean a person who makes business loans exclusively through the internet. Those are the provisions of the bill, and I'd be happy to answer any questions.
Great. Thank you, Mr. Fernley. We appreciate you being with us this evening. Questions from members of the committee? Senator Hansen.
Thank you, Madam Chair. So, Mr. Fernley, the question I have is, if somebody is supposed to be incarcerated currently, but has been released because of COVID concerns, does that now mean they can vote if this bill passes as is?
Thank you. I think the answer to that depends on the reason for that they were released. If it was because they were granted parole, then yes, they would be restored to the right to vote. If it was a home release program or a furlough, I don't believe that would apply because the bill refers to being placed on probation or granted parole.
Okay, thank you.
Additional questions from members of the committee? Okay, seeing none, thank you, Mr. Fernley. We appreciate you being here with us. We will now move to our public testimony portion on Assembly Bill number 1. If you wish to give public testimony on Assembly Bill number 1, this would be the time to do so. Of course, under this item, you can do so by phone. You can also do so in a written format. If you would like to testify by phone, please refer to the committee's agenda. There are directions there on how to dial in. Once you dial in, you'll be entered into a queue. And I would remind everyone that once you have dialed in, you must remain on the line in order to stay in the queue. Otherwise, you will lose your place. Because of time considerations, we will give each caller offering testimony 2 minutes of testimony, and we will be limiting testimony in the support, opposition, and neutral portions of this testimony to 30 minutes total. The lines are now open for public testimony. We will first take those who are in favor of Assembly Bill number 1, followed by those who are in opposition to Assembly Bill number 1, and finally we will finish with our neutral testimony on Assembly Bill number 1. Of course, if you have additional testimony outside the 2 minutes, or you would prefer to give written testimony or written comments, you may do so as well. They can be added to the meeting on the legislative website in lieu of that testimony. The email address for which you can submit your comments in writing is also noted on today's agenda. With that, we are going to turn it back over to our Legislative Council Bureau broadcast staff, doing a fantastic job of helping to facilitate our public testimony. And again, we will begin with those who are in favor of Assembly Bill number 1.
If you are for the bill, press star 9 now to raise your hand, and we will take callers in order. Again, if you are in favor of the bill, please press star 9 now to raise your hand, and we will take callers in order. Madam Chair, the public comment line is now empty. There are no more callers at this time.
No callers at all. I just want to make sure, because I've done this before and then missed out on some testimony.
Yes, Madam Chair, there are no more callers. The public comment line is open and working at this time. However, there are no more callers.
Fantastic. We appreciate your helping us out this evening with our public testimony, and of course keeping me on track as well. We will go ahead then and close our hearing on Assembly Bill number 1. What is the pleasure of the committee? Senator Brooks.
Madam Chair, I move that we do pass.
There's a second for the motion, Senator Cancella. You've heard the motion. Any comments on the motion? Senator Hansen.
Thank you, Madam President. My comments are I'm going to vote no on this for a couple of reasons. One, I oppose having people that have not completed their sentences voting. I voted against it during the session. Again, I don't think this rises to the standard of extraordinary concerns that should be being dealt with outside of a normal session. I think all of this could have waited till the regular session began. So I will be a no.
Additional comments from the committee? All right, seeing none, all those in favor, please signify by saying aye. Aye. Any opposed? We have two nays? Three nays. Senator Hansen, Senator Settlemeyer, Senator Pickard are nay. The motion carries. Assembly Bill number 1 will be reported from the Committee of the Whole to the Senate floor. At this time, the committee has concluded its business on this particular agenda. At this time, Senator Woodhouse.
Thank you, Madam Chair. I move that the Senate Committee of the Whole do rise and report to the Senate.
Senator Parks.
I second that motion.
You've heard the motion. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. All those opposed? Motion carries. The Senate Committee of the Whole is dissolved. We will be in a brief recess.
The Senate will come to order. Order of business number 4, reports of committee.
Madam President, your committee of the whole, to which is referred Senate Joint Resolution Number 1, Assembly Bills Numbers 1 and 2, has the same under consideration. Begs the report, same back recommendation do pass. Signed, Senator Nicole Canizaro, Chair. End of reports.
Thank you. Order of business number 9, motions, resolutions. Senator Canizaro.
Thank you, Madam President. I move to place Senate Joint Resolution Number 1, just reported out of committee, on the general file for the next legislative day.
Thank you. Senator Canizaro has made a motion. Are there any remarks? All right. Hearing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. Order of business number 16, remarks from the floor. Senator Canizaro. Oh, I'm sorry, Senator Hansen.
Thank you, Madam President. Just real quick, earlier in this legislative day, my colleague from District 17 issued a protest under Rule 31. I would like to have my name added to that protest as well, if I could. Thank you.
Thank you, Senator Hansen. It will be identified as a separate protest on its own, if that's all right. Okay.
That's perfect. Thank you very much.
Thank you. All right, Senator Canizaro.
Thank you, Madam President. I move that the Senate stand in recess to the call of the chair.
Thank you. You have heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. We're in recess. Good evening. The Senate will come to order of business number 6.
Assembly Chamber, Carson City, July 31st, 2020. To the Honorable Senate, I have the honor to inform your honorable body that the Assembly on this day passed as amended Assembly Bill number 4, signed Carol Ayala Sala, Assistant Chief Clerk of the Assembly. End of messages.
Thank you. Order of business number 10, introduction, first reading, and reference.
Assembly Bill number 4, introduced by Assembly Committee of the Whole, revises provisions relating to elections. End of bill.
Thank you. Senator Ratty.
Thank you, Madam President. I move to refer AB 4 to the Committee of the Whole.
Thank you. Are there any objections to the referral? If not, so ordered.
That concludes order of business number 10.
Thank you. Order of business number 9, motions, resolutions, and notices. Senator Canizaro.
Thank you, Madam President. I move that the Senate resolve itself into a committee of the whole for the purpose of considering Assembly Bill number 4 and other matters as outlined in the governor's proclamation, with Senator Canizaro serving as the chair and Senator Ratty serving as the vice chair.
Thank you. Are there any remarks? Okay. Hearing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. We're in recess.
Committee of the Whole will now come to order. Committee members, on our agenda this evening, we have before us Assembly Bill number 4, which revises provisions relating to elections. I will note for everyone who is following us online that the plan is to open the hearing on Assembly Bill 4, take testimony, allow the committee to ask questions, and then we will take public testimony in favor, in opposition, and in neutral for the bill. We will go ahead and open up the hearing on Assembly Bill number 4. A copy of this Assembly Bill is also available for everyone who is following online on our Nellis website, and it has also been provided to all of the committee members, also in a hard copy form. All the committee members should have a copy of Assembly Bill 4 in front of them. With that, what I'm going to do is open up the testimony on this. Senator Orenshaw, if you would like to walk us through the bill, and then I believe we should have Mr. Powers as well to talk to us about some of the provisions in Assembly Bill number 4, and then we'll move on to some questions. Senator Orenshaw.
Thank you very much, Madam Chair. Madam Chair, members of the Committee of the Whole, the bill before you today is a critical measure that ensures that our election system can endure the current crisis our state faces, as well as any future emergency situations that our state may face. This legislation will provide for the successful conduct of elections during emergencies and disasters. Never before has our state experienced such a public health crisis, and during a critical election year like this, we must be prepared to ensure that the right to vote and participate in democracy is protected. Assembly Bill 4 gives our state the flexibility to make sure that scheduled elections can still go forward and take place, even during a state of emergency or a declaration of disaster. Assembly Bill 4 will allow every voter to have the opportunity to vote by mail if they choose. However, Assembly Bill 4 also allows our constituents to vote in person, either during the early voting period or on Election Day, if they prefer to vote in person. Assembly Bill 4 is intended to ensure that Nevada's elections are conducted safely and securely when the occurrence or existence of an emergency situation, such as we are currently facing, adversely affects the public's health, safety, and welfare, and the ability of election officials to prepare for and conduct those elections. The bill sets forth a legislative declaration stating that if an emergency or disaster occurs, Nevada's election officials will have certainty in their ability to conduct elections safely and securely, and that voters should have faith that they can participate fully and without fear for their health, safety, and welfare. Assembly Bill 4 addresses numerous procedures related to early voting, polling places on Election Day, voter registration, mail ballots, absentee ballots, costs of the election, and the counting of ballots in the context of running elections during a declaration of emergency or disaster. I urge this committee's support of this critical legislation that will help make sure that in times of crisis, our constituents will still be able to safely cast their vote. Madam Chair, with your permission, I'd like to ask Mr. Powers of the Legal Division of the Legislative Council Bureau to walk us through the measure, and I'm happy to answer any questions after he's done.
Fantastic. Thank you, Senator Orenshaw. And Mr. Powers, whenever you're ready, we'll go ahead and turn the floor over to you.
Thank you, Madam Chair. For the record, Kevin Powers, General Counsel, LCB Legal Division. As you know, the LCB Legal Division is a nonpartisan legal agency. We do not support or oppose any particular piece of legislation, policy, or viewpoint. Instead, we provide the legislature and its members with objective legal advice regarding the legislation, whether it is constitutional or not, or its legal effects or consequences. And that's why I'm before you today to explain this piece of legislation, its legal mechanics, and some of the legal effects and consequences if the legislature were to adopt this legislation. Before I get into the bill itself, it's important to understand how the existing statutes are set up with regard to elections in Nevada. Elections are covered by several chapters of NRS that are entitled 24 of NRS. Chapter 293 governs all elections to a certain degree and creates general procedures. In addition, there's Chapter 293C of NRS that applies to cities, and cities are either created by general law, by a charter creating the commission form of government, or by a special charter enacted by the legislature. And because of the differences between cities and then counties and the state, there are different provisions in the law that supplement general procedures but apply specifically to those cities. Because of the way the statutes are set up, when you're dealing with the mail-in type ballots, that would be absent ballots, mailing precinct ballots, or military overseas ballots, there are separate subheadings in Chapter 293 of NRS, 3 of them in fact, and then in 293C of NRS, there's similar subheadings there. The result is that when you want to create a uniform procedure for dealing with mail-in ballots, you need to amend every one of those areas of the law. So you end up having 6 different sections that have repetitive language in them. And that would explain why the bill before you is so long. Sections 2 to 27 are the bulk of the bill when it comes to elections affected by emergencies or disasters. The rest of the bill following those sections, 28 through roughly 84, those where we go through the existing sections of NRS and put in the same procedures for absent ballots, mail-in precinct ballots, and any other type of mail ballot. So although the bill is lengthy, the reason for it is having to address repeatedly those similar sections of the law so that there's uniform procedures to address these types of mail ballots. Having said that, then we'll take you back to the beginning of the bill, sections 2 to 27. That's the heart of the legislation. This legislation is tied to a declaration of disaster or a declaration of emergency by the governor under existing law. The trigger for the legislation is in Section 8 of the bill. And there's three separate subsections in Section 8 that we will address. The first subsection is subsection 1 of Section 8. Under that provision, if the governor or the legislature by resolution issues a declaration of disaster or a declaration of emergency that applies to the entire state, and that declaration is in effect on a particular date set by statute before the election, then that's an affected election, and the provisions of Section 2 to 27 kick in and cover the operation of that election. The subsection 1 is automatic if the statewide emergency is in effect on that particular date preceding the election. Subsection 2 creates discretion in the governor. If a declaration of emergency or disaster is issued after those dates set forth in subsection 1, and it's a statewide emergency or disaster, the governor has the discretion to deem the election an affected election that's subject to sections 2 to 27. And then those provisions would begin. In order to do that, the governor has to find that the emergency would impair the health and welfare and safety of the public in conducting the election, and that there was sufficient time before the election to implement sections 2 to 27 and the federal law provisions dealing with the election. So that's the discretionary part for the governor when there's a statewide declaration of emergency. Finally, in subsection 3 of Section 8, that's where the declaration of emergency or disaster applies only to a specific area of the state and not to the entire state of Nevada. Under those circumstances, the governor finds that the emergency would adversely affect the election and the public health and safety and welfare of the people, and also that there was sufficient time before the election to invoke the provisions of section 2 to 27, then the governor could order that election in that locality to be an affected election by the emergency or disaster, and thereby subject to sections 2 to 27 of the legislation. Those are the triggering mechanisms for the legislation. In addition, in Section 85, the bill includes a provision to make it clear that sections 2 to 27 for the affected elections apply to the 2020 general election. If this legislation is enacted, the emergency provisions of Section 2 to 27, creating the new election structure for under these emergency circumstances, would be applied to the 2020 general election. So the next parts of the bill to discuss are sections 9 and 10. Those are sections that provide rules or standards of interpretation to interpret these provisions in conjunction with existing provisions governing elections. Under section 9 and 10, if a provision of another election statute conflicts with sections 2 to 27 and an election that's being conducted under sections 2 to 27, then sections 2 to 27 supersede and take precedence over those other statutory provisions. However, if there's other election statutory provisions that do not conflict with 2 to 27, then those other statutory provisions still continue to be applied, and they have to be applied harmoniously in conjunction with sections 2 to 27. In addition, sections 9 and 10 also make clear that when an election is being conducted under sections 2 to 27, it doesn't adversely affect the provisions of the Uniformed and Overseas Citizens Absentee Voting Act, which covers military overseas ballots. So the provisions of that law, both federal and state, stay in place and operate in conjunction and in harmony with sections 2 to 27, even during an affected election. The next sections to talk about are sections 11 through 14. These sections set up the required minimum number of polling places that each local jurisdiction needs to maintain while they're conducting the affected election, which will be mostly a mail ballot election. However, even though there will be mostly a mail ballot election, there will be polling places established. So each of these sections establishes minimum number of polling places in each different jurisdiction for early voting, or election day voting at vote centers. It deals with the issue of same-day rate registration, both for early voting and election day, and make sure that there are same-day registration polling places during those periods. It also provides that if an Indian reservation or colony wants to go through the statutory process of having a polling place on the Indian reservation or colony, there are provisions that they can follow that if by September 1st, for example, before this election, they invoke their right to have a polling place on the Indian reservation or colony. They can do that under this legislation. In addition, there's provisions in existing law dealing with having a polling place in residential facilities dedicated exclusively for elderly people. Those provisions are also in place here. They would be part of an affected election, and those facilities could ask to have a polling place established at that location. The next provisions of the bill to talk about are 15 and 16. Under those provisions, each county and city clerk is required to issue a mail ballot to each active registered voter in their jurisdiction. And that would require the mail ballot to go out at a certain time. In particular, with regard to those voters entitled to a military overseas ballot, distribution of those ballots generally has to occur no later than 45 days before the election. So as part of this mail ballot, those ballots would go out to the military and overseas voter, and then the mail ballots a certain number of days before the election then would also be issued within the local jurisdiction as well. Sections 18 and 19 and 20 deal with the process of the voter voting their mail ballot under the provisions of this bill. Section 18 makes clear that even though a voter has received a mail ballot, the voter can still apply to vote in person at a polling place where they have to either surrender the mail ballot or sign an affidavit declaring under penalty of perjury that they have not voted in that election, and therefore there's an option. Not every person who receives a mail ballot is required to send it back in the mail. If they choose to take that mail ballot to a polling place, they can surrender it and vote in person. Section 19 contains provisions with regard to a voter who is with a physical disability, is at least 65 years of age, or unable to read or write. This authorizes that voter to have someone mark and sign the ballot on behalf of the voter, or assist the voter in marking and signing the ballot themselves. If a person is involved in assisting or doing it on behalf of the voter, that person must comply with certain requirements, including signing a document that goes back with the mail ballot indicating the name of the person who provided the assistance, their address, and their signature. Section 20 sets up the process for counting the mail ballots and how they must be timely returned. The mail ballots have to be either delivered to the county or city clerk or dropped off at a ballot drop box or postmarked on or before the day of election and received by the clerk not later than 5 p.m. on the 7th day following the election. So those are the options for returning the mail ballot instead of bringing and surrendering it in person. There are provisions in here for each county to establish at least one location for a ballot drop box, but that's a minimum. Counties can establish more locations for a ballot drop box. And this bill also provides for the standards that each of the ballot drop boxes must meet. Again, if a ballot drop box is not located at a polling place, the voter can still come in and surrender their mail ballot and vote in person at that voting location. Section 21 provides that a voter who has received a mail ballot and filled it out can authorize another person to return the mail ballot on behalf of the voter, either by mail or personal delivery. However, Section 2 also creates unlawful acts that a person can engage in who has been given the responsibility of returning the ballot. If that person does anything to impede, obstruct, prevent, or interfere with the return of the ballot, deny a voter's right to return the ballot, or fail to return the ballot willfully within a certain period of time, then that voter has committed a crime under the election laws, and that's considered a Category E felony. So although a voter can authorize the return of the ballot, someone who fails to return when they're given that responsibility does face criminal liability under certain circumstances if they act willfully. Sections 22 and 23 deal with the process of verifying the mail ballots when they're returned to the county clerk. In particular, Section 23 sets up standards for the county and city clerks to determine whether there is a reasonable question of fact as to whether the signature used for the mail ballot matches the signature of the voter. There's a procedure that the county and city clerks go to verify the signature. If there are issues with the ballot at that time because signature verification can't be accomplished or the voter failed to sign the ballot or failed to sign the ballot in the proper location, There are procedures where the clerk needs to contact the voter and give the voter an opportunity to correct or rectify the errors or omissions on the ballot. And there's a period during which the voter then has to do it. And generally that period ends on the 7th day following the election at 5 p.m. And like I said, this requires the clerks under those circumstances to contact the voter by mail, by telephone if the clerk has a telephone number on file for the voter, and by electronic mail if the voter has previously provided the clerk with sufficient information to contact by electronic mail. Finally, sections 24 through 27 establish the process for the mail ballot counting board to count the ballots as they come in, and the mail ballot counting board has to go through a procedure to verify the ballots that they're accurate, that the voter was entitled to vote, and the voter has not voted already in that election. And then, as I said, the remaining sections of the bill mirror a lot of what's in these 2 to 27 sections with regard to processing absent ballots and mailing precinct ballots. So even if an election is not an affected election under section 2 to 27 and those provisions don't apply, the remaining sections of the bill ensure that the procedures I talked about, as allowing another person to return a ballot, assisting a voter in filling out the ballot, and the signature verification process, those processes have now been mirrored under absent ballots and mailing precinct ballots, so that there's a uniform set of procedures for all state, county, and city elections when it comes to a mail-in ballot. And again, that is the reason for the length of the bill, because there are at least 5 or 6 different sections that mirror each other in Chapter 293 and 293C, and all of those sections must be put together in a similar fashion so that there's obviously consistency and uniformity application. Finally, the bill does contain a monetary component. That is in Section 84. That provision was also amended in the Assembly. What the provision provides is for the transfer of $3 million of federal money to the Secretary of State. That Secretary of State will use that money to help the local jurisdictions in conducting the mail ballot portion of the affected election during the 2020 general election. The provision also in 84 contains a series of provisions that if additional federal money comes in, additional federal money could be used for the mail ballot portion of the 2020 general election. And then again, as I emphasized, Section 85 makes clear that these provisions, Sections 2 to 27, and the provision transferring the money apply to the 2020 general election. And if this legislation is passed, therefore, then these provisions in Sections 2 to 27 will kick in for the 2020 general election. Thank you, Madam Chair. That is an overview of the legislation. I'm certainly open to any questions the committee may have.
Thank you, Mr. Powers. We appreciate you walking us through that bill. Members of the committee, we are also joined remotely by Joe Gloria, the Clark County Registrar of Voters, and also our Secretary of State, Barbara Sagowski, and her Deputy Secretary of State, Wayne Thorley. They will be available for any questions should members of the committee have any questions that they may be able to answer. I would remind committee members we will go through and allow everyone to ask their questions, but not to go through twice, so make sure you think of those questions ahead of time. We will start with Senator Gocochea.
I'm sorry, Madam Chair. I was looking
That's
and
okay,
thinking
I was
here.
pretty fast.
This question to Mr. Powers, if we can walk back to Section 13, I just need to walk through the process on the same day voting in those counties under 100,000. I have a number of constituents that do, in fact, want to vote on Election Day in person. Now, would they be able to then, they have to, it sounds like they have to carry the ballot that was mailed to them in with them, surrender that, and then they would vote at a voting machine as they previously did, or how does that work?
Thank you, Madam Chair. For the record, Kevin Powers, General Counsel. That is correct. The provision in the bill that deals with surrendering the mail ballot is in Section 18, subsection 3 on page 15. What it provides is that if a voter's received a mail ballot, but once the voting person, they show up at the polling place, either during early voting or on election day, they have to surrender the mail ballot, or if they do not have the mail ballot with them, they can sign an affidavit that they have not voted in the election, and they would be authorized to vote at that point. Of course, county and city clerk would verify after the voting that they in fact did not vote in that election. And if a mail ballot were to come in after that, there would be a record of them voting, and that mail ballot then would be invalidated because they had voted. So yes, any voter who receives a mail ballot can bring it in to their polling place and surrender it at that time or sign the affidavit. In addition, a voter can actually bring a completed mail ballot to a location that has a ballot drop box and drop off the ballot physically at the clerk's office or a polling place if there's a ballot drop box available at that location. So that is an option. In addition, this bill does require certain jurisdictions to have a certain number of polling places available on election day, depending on the size of the jurisdiction. And these are minimum requirements. No jurisdiction is prohibited from having an additional amount of polling places that makes sense for that jurisdiction. In addition, even if a jurisdiction doesn't do a vote center, and a vote center is a polling place where anyone in the county can vote at that location, even if a jurisdiction doesn't have those vote centers, the jurisdiction has to maintain at least several polling places located throughout the county where voters could go for their particular precinct and vote at those polling places. And keep in mind that even if you don't have a vote center, local clerks, they can create polling places that have multiple precincts in them. So you don't have to create a separate polling place for each precinct. You can actually consolidate precincts into voting districts. And so even if you don't have vote centers, you can have 5 or 6 or 10 or how many polling places you need with consolidated voting districts, providing essentially subsets of vote centers where voters can go on the day of the election or during early voting and vote at those locations. Thank you, Madam Chair.
Thank you, Mr. Powers. And I just wanted to be clear on that, the fact that they could, in fact, walk in. It sounds like they signed the affidavit. That would not be a whole lot different from them actually signing what we've done in the past, signing a signature to receive the ballot. So I thank you, sir, and I think you will see in a lot of the rural areas they prefer to vote in person. Thank you.
Senator Settlemeyer.
Thank you, Madam President. I was curious on Section 8, where it says that the emergency is in effect. How do we know when a state of emergency is no longer in place? Because I don't believe there's a date or a time frame on it, so how do we know that? I guess that question is to Mr. Powers.
Thank you, Madam Chair. Thank you, Madam Chair. Again, for the record, Kevin Powers, General Counsel. That's controlled by Chapter 414 and the power of the legislature and the governor to make a declaration of disaster or proclaim the state of emergency. When, in this case, we'll use the governor just because we're familiar with that. If the governor issues a state of emergency or declaration of that disaster by proclamation, that remains in effect until the governor issues another proclamation terminating that state of emergency or declaration of disaster. So we will know whether or not a state of emergency or declaration of disaster in effect is whether or not the governor has terminated. So there is a definite date in the law. It's just not in the legislation. It's in existing law in Chapter 414. Thank you, Madam Chair.
So in that respect, Mr. Powers, would it be safe to say then if he does not issue something saying that this emergency is over, that it would be in perpetuity?
Thank you, Madam Chair. For the record, Kevin Powers. That certainly is a possibility. Seems unreasonable and unrealistic. However, the legislature has the power to then come into a session and end the state of emergency or declaration of disaster if the governor chose to have a state of emergency last in perpetuity. So the governor is not the only constitutional officer or entity that has control over states of emergency. The legislature itself has that power as well. Thank you, Madam.
If I could continue on with questions, I had a question I believe probably best suited for the Secretary of State. How long will this potentially prolong the counting of this election? How long will we expect to have to wait in addition to, generally at 7:20 at night, we tend to get election results and have a pretty good idea of how the election is going. How long will this potentially add to that time frame?
Oh, Madam Secretary of State, we can't hear you.
Mute button, probably.
Can you hear me now?
Yes, now we can hear you. Thank you.
Okay, thank you. My name is Barbara Sagaski, Secretary of State for Nevada, and I am joined here with Wayne Thorley and Senator Suttlemeyer. And Madam Chair, if you don't mind, I'd love to have Wayne Thorley talk about that.
Yes, please.
Good evening, everyone. My name is Wayne Thorley, Deputy Secretary of State for Elections. Can you hear me?
We can.
All right. Thank you, Madam Chair. So the time that it takes to count ballots is wholly dependent on how many voters will choose to vote their mail ballot rather than vote in person. The counting and tabulation of ballots cast in person on the touchscreen voting machines is a very quick and easy process. The process of counting the paper mail ballots is a little bit longer, so it could take more time if there are a lot of ballots cast by mail. There is a provision in this bill that allows the counties to start counting ballots on the front end 15 days before the election. In current law, that is 4 working days before the election. So the language in this bill would give the counties more time on the front end to count ballots that they've received, which could save time on the back end.
With that, if I get a clarification, so you're indicating then that 15 days prior to the election date, there will potentially be people within a county that already start to have an idea potentially of how the result of that election could occur?
Wayne Thorley for the record. When ballots are counted, what that means is the counting board, which is a bipartisan board that is appointed by each county clerk or registrar of voters. That means they go to work. They open the ballots, they do ballot deconstruction, separate the ballot from the envelopes, and then they start running the ballots through the scanners, the digital scanners, and they do adjudication or duplication as needed if the ballot's damaged or if there's an overvote or a voter intent in question. They do all that stuff. But there's nobody, while that's done and the votes are tracked, it's all on the back end on the computer. And Mr. Gloria can certainly go into more detail on this than I can, but it's my understanding nobody's looking at that. There is existing law, and I believe it stays in place in this bill, that makes it a misdemeanor to release election results prior to the close of polls on election day, and that would stay in effect. So even if somebody on the counting board did know or got a peek at how the election results were going, they would not be allowed to release that.
Okay. One last question, if I could, and I'll quit monopolizing the time. I was curious, though, this bill obviously contains an unfunded mandate that was not requested by the affected local government. I see in the Assembly version they put $3 million potentially of CARES Act funding in. Is that enough to cover all the costs, or will there still be an unfunded mandate to those local governments?
Wayne Thorley, Deputy Secretary of State for Elections. Madam Secretary, did you want to take that one?
No, go ahead. You go ahead.
So the $3 million in the first reprint amended version of the bill is for costs related to the preparation and distribution of mail ballots pursuant to the provisions of Section 2 to 27 of the bill. It's probably instructive to talk about how much the primary election costs, since we just went through a mostly vote-by-mail election just last month. The printing and mailing of a ballot to every active registered voter costs approximately $2 million. Each ballot package costs a little over $1 to manufacture. That includes the envelopes and all the materials, including the ballot that go inside the envelope, and then outbound postage. The bill does require the ballots, these mail ballots that are sent in an affected election, to have postage prepaid ballot return envelopes included. The cost for that is dependent entirely on how many voters vote by mail and then also return their mail ballot through the post office and not dropping it off in person at a drop-off location. For the primary election, the business reply mail account that we created with the post office ended up getting charged just over $400,000 for ballot return costs for the primary election. Assuming turnout will be larger for the general election, the ballot return costs, ballpark figure, $600,000 to $700,000. So between ballot printing, outbound postage, and then inbound postage, ballot return, we're getting somewhere close to that $3 million that's in the bill. Other activity that we undertook for the primary election that we believe would be important for the general election is voter education. Given the significant changes that are proposed in this bill to how voters in this state are used to voting, and then also given just the need to inform voters, given so much misinformation out there, we would certainly want to do some extensive voter education. We did so for the primary. That cost $750,000. A similar voter education campaign for the general would be a little bit more money. We're thinking about $1.5 million because the airtime, so we did a lot of radio and a lot of television advertising, and we got a good deal because there was not a lot of competition for airtime on media. We anticipate for the general election there would be much more competition with candidates for federal office buying up a lot of media airtime. So we anticipate it costs about $1.5 million for voter education. So the $3 million would cover printing, outbound postage, and return, but would not be enough to cover voter education. And by my reading of the bill, I don't even think we could use that $3 million for voter education because it says specifically in that Section 84, I believe, that the $3 million is for the cost related to the preparation and distribution of mail ballots.
Okay, thank you. Thank you, Madam Chair.
Senator Hardy.
Thank you, Madam Chair. My questions are around the person who assists the person who may be having a physical disability, 65 or older, unable to read or write. If this person, first of all, I'm going to ask a series of questions. How many people can a person act as an assistant to fill out the ballots? And this person who assists would probably be under the same obligation as the clerk would be in Section 27, keeping the ballot secret. And in that same section, if that person then starts counting, I did 2 people, I helped 2 people, and they both voted for candidate X, that would probably qualify for a crime as a misdemeanor if he were to say that before the election. And so what is the obligation? What are the obligations for the person who helps the other person prepare the ballot? And what are the things that hold him accountable or her accountable to do that?
Thank you, Madam Chair. It's Kevin Powers, LCB Legal Division General Counsel. Mr. Thorley doesn't mind. I can take that to begin with. And first, Senator, although subsection 3, section 27 does create the misdemeanor, That's for any person who disseminates to the public in any way information pertaining to the count of mail ballots. Someone who assists another voter to prepare a mail ballot would not have information about the actual count, how many votes were going towards one candidate. It's true that if you helped out multiple candidates, you would know how many people those individual could have voted for, but they're not involved in the process of counting the mail ballots. There is a provision that's in section 53 of the bill that talks about that a voter cannot show his or her ballot after voting to another person unless it's a mail ballot, absent ballot, or mailing precinct ballot. So it is okay for a person to show their vote to another person, and once that person has that information, that person can disclose the information that person X told them about who they voted for. That is not prohibited by the law. If it is somebody who does that for multiple people, then they would have information on those multiple people. Keep in mind, though, someone who is authorized to assist another person and prepare the ballot is limited to the people who they can assist. It has to be someone with a physical disability, is at least 65 years of age, or is unable to write. So that is a smaller subset of the population. Nonetheless, it is theoretically possible that one individual could assist multiple other people to have some information about who those individuals voted for. But there are no provisions specifically in the bill that prohibit someone who assists a voter from voting from disclosing the information that they found on that ballot.
So as I read it, there is no accountability for the person who assists to not share that with someone else and thus make the ballot not a secret ballot.
Thank you, Madam Chair. For the record, Kevin Powers. I do not believe there's a provision in law now that prohibits the person who assists from sharing that information with another. Obviously, the person who assists has to identify themselves in the return mail ballot. They have to give their name and their address, and they have to provide their signature. But as I understand it now, there is no provision in the law that prohibits them from disclosing that information to another person.
Nor is there in this bill proposed to do such a thing. Question mark.
For the record, Kevin Powers, that is correct.
Thank you.
Senator Hammond.
Thank you, Madam Chair. Yeah, it's a long night. I'm sorry, I misunderstood my name actually when you said it. I guess I have a question, probably best for Secretary of State, if she could. This bill purports that most of what we're dealing with is trying to keep people safe during the age of COVID. So after reading the bill and wondering about your capacities and what what your office is doing, do you feel that you actually have the resources and the capabilities, the tools, if you would, to actually maintain a safe election and a fair election without the passage of this bill?
Thank you, Madam Chair and Senator Hammond. Can you hear me?
We can hear you.
Okay. This thing keeps popping up, so I just want to make sure. Okay. Thank you again for the question, and I'll answer some of it, and then I'll hand it over to my deputy, Wayne Thorley. Yes, the answer is absolutely yes, we can. We've done it. As long as I've been Secretary of State, we've been able to, make fair and what I feel are very good decisions with the 17 counties. The 17 counties are taking up all of the means of getting the hand sanitizer, making sure that the machines are cleaned after they're used. All of those things that they need to do, the 17 counties are doing. And we're very proud of them and worked with them quite extensively on this. But if it's all right, Senator Hammond, I'd love to have Wayne Thorley, our Deputy for Elections, talk a little bit about this as well. Is that all right?
Sure. And just as a side note, I also kind of wanted to know how long you have had to actually review this particular bill because that helps me to understand what you know about it.
How long what? I didn't hear you.
How long have you, I guess, when did you get a chance to start reviewing the bill? When did you get this bill in your possession so you could actually review it and understand it?
Well, I can answer that, and then I can turn it over to Wayne. And again, this is Barbara Sagaski, Secretary of State. And thank you again, Madam Chair and Senator Hammond, for the question. We got it at the same time everybody else did. We got it probably an hour before it was heard in the Assembly side. And unfortunately, we had reached out for the last several months trying to find somebody to work with or to talk to about this bill, and to see if we could be helpful. And we were, nobody responded to us as far as working with the bill. So our input only came today in the Assembly and then tonight in the Senate. So thank you for that question. Wayne, do you want to answer his first question, and you can go into the second one that he asked?
Wayne Thorley, for the record, Deputy Secretary of State for Elections. If I could ask Senator Hammond, could you please restate your question so I make sure I'm answering?
Absolutely. Wayne, what I asked was, given the nature of this bill and what was stated about the need for it in order to have a safe election, I just wanted to know if you already, in your estimation, possess the tools necessary to conduct an election in November in a safe and fair manner.
Thank you for restating the question. Wayne Thorley, for the record. I do believe so. The CDC has issued guidelines about how to structure polling places for in-person voting. It's also released guidelines for how to work on the tabulation of mail ballots. And as the Secretary mentioned, the counties are excellent at following these guidelines. We worked on them for the primary election. Certainly for the general election, we would continue to follow all the guidelines from health officials regarding social distancing, the proper wearing of PPE for our election workers, obviously encouraging all voters who vote in person to wear a mask. There will be hand sanitizer, sanitizing equipment and wipes available for the hard surfaces, plexiglass partitions between voters and election workers, so that we can make sure those that choose to vote in person are kept safe, and also our poll workers, who are extremely appreciative of every year, but especially appreciative of this year, that they can stay safe during the time that they're working the polls.
Okay, thank you. And just to make sure I understand, and those who are brave and hardy and are still up listening to this, just to make sure I understand and reiterate this, even without this, if we didn't pass this bill, the Elections Department, the Secretary of State's office, you would be able to conduct an election that is both safe and fair, just as you have in the past.
Wayne Thorley, Deputy Secretary of State for Elections. Yes, we believe so.
Senator Pickard.
Thank you, Madam Chair. Mr. Thorley, maybe you're probably the best person to answer the question. I'm looking at sections 19 and 21 to pick up from my colleague's question about those that are assisting others, and then, of course, in 21, those that are collecting and turning in the ballots. How would, well, first let me ask, is it your office that's responsible for investigating and prosecuting the offenders that are reported to you?
Wayne Thorley, Deputy Secretary of State for Elections. Senator Pickard, our office is responsible for investigating alleged violations of election law. Some Sometimes we bring in other offices to help us with those investigations. We sometimes bring in law enforcement at both the state and federal level to help us with those investigations. As far as prosecuting, the Secretary of State does not have prosecutorial power, and it would be on the district attorney or the attorney general to prosecute any violations of election law.
All right. And how many investigators do you employ?
Wayne Thorley for the record. The Secretary of State's office has one part-time compliance investigator that we share with our commercial recordings division to investigate alleged civil violations of election law. The Secretary of State's office also employs several sworn peace officers. They're not sure the exact number. It's about 5, I believe. They are employees of the Secretary of State's Securities Division, so they are not employees of the Elections Division. However, they do assist on election cases as needed.
All right, and I appreciate that. So we're talking about 6 or 7 maybe people that are responsible for doing all of the investigation in their normal activity, plus the part-timer that investigates for your office to cover the entire state. So answer, if you would, how do we find out that this ever happened? I'm imagining someone going to a door, particularly, because I've seen this in my own district. I've got a couple of active adult communities, and there are lots of volunteers going around trying to help people get the vote into, it used to be they would take them to the polling place. Now it's getting the ballots into the mailbox or into the drop-off box. What is to stop a person from saying, oh, gee, ma'am, can I help you fill this out? And I'll take it to the mailbox for you. And they say, okay, yes, please, that would be wonderful. They help them fill it out, and then they take the ballot, and then the voter thinks that that's been deposited. How do they know if that was deposited? Is there a mechanism in this bill somewhere or in the process of your office that makes sure every voter gets a confirmation that their vote was put in? Because it's a felony if they don't drop it off, but if it's not reported and nobody knows, it's like a foul in a sports game. If it wasn't caught, it's not a foul. Is that a fair statement?
Wayne Thorley, Deputy Secretary of State for Elections, for the record. With many aspects of alleged election violations, we rely heavily on members of the public to report alleged violations of election laws to us. We obviously cannot be everywhere at once and cannot know what's going on at all times. So we do have an online complaint form that anybody can fill out. And if there's an alleged violation of election law, send us a complaint form, attach and provide any evidence they have to support those allegations, and then we'll take a look at that. But yeah, certainly we can't know everything that goes on.
Sure, but that presupposes the voter's knowledge of the violation. If they don't know about the violation, it's never going to be caught, correct?
Wayne Thorley for the record. Are you asking if the voter doesn't, in your hypothetical, if the voter doesn't know that their ballot wasn't turned in, that issue would never be caught? Is that the question?
Correct.
Wayne Thorley for the record. When it comes to providing information to voters about the status of their absentee or mail ballot, voters have several options to confirm that their ballot was received by election officials. Voters in our large counties, for example, Clark County, can log on to their registered voter services portal and look up all sorts of information. They can verify their registration status, see a sample ballot. They do lots of things, but one thing they can also do is they can see when their mail ballot was mailed out to them, and then they can also see the date that it was received by the county. So they can get confirmation that way. Voters can also log on to the Secretary of State's My Voter file, and it's very similar to Clark County's Registered Voters Services portal, and they can confirm that the county has received their ballot that way. Of course, any voter can reach out to their county via email or phone call and ask, and they would be more than happy to provide the voter with the status of their ballot.
All right, I appreciate that. I just think that particularly in the vulnerable population that we're talking about serving, they are much less likely to be sophisticated enough to be able to access those sites. I would submit that they're going to assume that they got there, and there will be absolutely no way of us knowing that anything untoward has happened. Thank you, Madam Chair.
Senator Hansen.
Thank you, Madam Chair. My question follows along similar lines. For me personally, when I voted, I was thinking about it. I stand in line. There's a voting machine. Nobody is allowed to stand within several feet of me while I vote. That is to ensure I have a safe, impartial, and secret ballot completely. Now, with this new process, especially under Section 19, what I can see very easily happening is somebody going into, for example, a rest home, and then saying, well, almost all the people in there would qualify for all of the issues here. Possible physical disability, 65 years of age, maybe unable to read or write. And the potential for not only not having a secret ballot is enormous, but the possibility of even being pressured to vote a certain way because whoever's helping you fill it out is in fact going to know exactly how you voted. And it's going to probably do some level of going through a rest home or whatever and encouraging other people as well. I mean, it totally, this bill and this section totally eliminates one of the most critical things that we've developed in America, and that is to ensure that everybody who votes, nobody knows but you how you vote. This eliminates secret ballots. It places senior citizens at a tremendous disadvantage. It also opens up people to potential pressure because somebody is going to know how you vote. And if somebody is in a rest home and is actually assisting numerous people to vote, then it's only logical to assume that they're going to possibly encourage them in a certain direction. So is there anything, Mr. Thorley or Kevin or whoever, what protection is there to ensure that you have a true, secret, safe, and secure ballot? That's what's missing in this whole thing.
Thank you, Madam Chair. For the record, Kevin Powers. I think first and foremost, every voter who doesn't face the situation of needing the assistance of another voter has the right to keep their ballot secret. However, that voter can also disclose their vote to whomever they want, and so that person who receives the information can further disclose it to whomever they want. The situation of someone providing assistance to a voter is unfortunate that that voter needs that assistance. But again, the voter selects who would be helping them fill out the ballot and assist them in returning the ballot to the county clerk. So really it comes down to the voter controls most of those functions. In the situations where the voters feel pressure, that situation where a voter would feel pressure under any other circumstance when they're needing the assistance of another.
But is there, Kevin, don't you?
As far as a legal penalty, there is no legal penalty involved in that situation.
Correct. So there's no penalty, there's no oversight, there's no way to, in effect, protect people's impartiality when they vote, especially if you're in a senior citizen home or you're somebody that already is physically challenged. I mean, the potential for abuse here is enormous. So I'm just amazed that something like this would even be seriously considered after all of the efforts we've gone through in America and in Nevada to protect the concept of a secret, safe ballot. Nobody has any business when I vote how I voted. If I want to express that to somebody, that's obviously my choice. But to actually know at the time I'm voting what that is, and then have the ability to go and then use that to influence other people in the same rest home, for example, as to how to vote. I mean, it's going back to the old days when they used to have marked ballots, and people could literally look at the number of the ballot that you received and find out how Ira Hansen voted, for example. So I don't know. I think the concepts, especially in Section 19, just is ripe for all sorts of flat-out criminality, if not abuse of people who are obviously, to qualify, are perhaps physically, even mentally challenged. It's frightening to me that we're even considering something like that in a state law. Thank you, Madam Chair.
Senator Severs-Ganser.
Thank you, Madam Chair. I want to talk about or ask about a couple of areas. One is it's hard to track in the bill, but if you look at the Legislative Digest, starting line 133, it talks about individuals who can turn in ballots for other people, and we have limited that to family members since, I believe, 1999. Chris Giuliani sponsored or amended a bill, AB 614 at the time, and said, yes, people can turn a ballot in on behalf of somebody else, but it needs to be a family member. But now we're amending sections 21, 40, 44, 70, and 75, and allowing someone to turn in a ballot on behalf of someone else. And we just had a discussion about folks who can't do it themselves and they're disabled, they're over 65 and certain criteria. When those people turn in a ballot on behalf of somebody else, they're actually required to provide a written statement. And if you have someone who's providing a written statement because they're turning in a ballot of someone who they otherwise probably don't know, that makes some sense to me. And my thought is if we're going to have someone other than a family member turn in a ballot, we probably should have a database gathering the information of who's doing that. So the same type of written statement or some sort of documentation as far as who is turning in a ballot if they're not a family member, which has been established in statute for over 20 years. So I would suggest that would be a good amendment to this to make sure that we can secure, and I know a lot of people are concerned about ballot harvesting, like mass quantities of ballots being turned in by people who don't really know the voters, unlike what we've had long established as far as family members. And if we were able to keep that information and treat it more like we are with folks who have disabilities, that might be a solution for that issue. Then I had a question around Section 15, or excuse me, Section 25, when there's in 26, when counting is started 15 days in advance, it talks about in 26 that the roster must show that they're voted. I want to know if that's an electronic roster. How do we keep track as we're getting ballots? So when we early vote, we purge the databases so we know who votes every day. Is this system, this 15-day early count, going to be the same or similar? Maybe this is a Wayne Thorley question, as when you early vote, but it's going to be documented on a roster, and is that an electronic roster so that it's uploaded and that information is available or not available? So that, again, sections 25 and 26.
Wayne Thorley, for the record, Deputy Secretary of State for Elections. This is actually probably a better question for Mr. Gloria. I would like to correct one statement I said previously. I got a text message. We have 7 sworn law enforcement officers in the Securities Division of the Secretary of State's office.
Okay, again, just going back to the question for Mr. Gloria, perhaps. How are we marking the roster voted when we're doing early counting of ballots?
For the record, Joe Gloria, Registrar of Voters, Clark County. Senator Ganser, thank you for the question. It is tracked electronically, and so every ballot that comes in is electronically scanned and immediately tagged whether the signature is good or it goes into a status of RM or RS, which is missing signature or signature not matching. Those that are passed on the first go-round as a good signature are marked voted and then sent to the counting board to separate so that it be sent over for tabulating. That's how it's marked in the system, and that's how we are able to tag that in registered voter services, as Mr. Thorley described earlier, and voters can go out and verify by date that their ballot was verified, processed, and it's going to count.
Thank you very much. If I can ask one more question, what happens when you get a duplicate? So someone had turned in their mail-in ballot, and then it turns up that same person supposedly voted. What happens? Which is a valid vote? Do you have to go back and find that ballot and check the signature if it's been turned in by hand? But then you get electronic. I guess the electronic might happen first, and then you get somebody who would turn one in, so you wouldn't know it until you open the envelope. Do you have an issue with duplications at all?
Again, for the record, Joe Gloria, Registrar of Voters, Clark County. Are you referring to duplicate mail ballots, which is a scenario that does occur from time to time, or when somebody is sent the mail ballot and then shows up in person to vote at one of the early voting or election day sites? Then
the latter, more likely.
So the system, since we're sending out to all voters, anybody who shows up in person will have to have them either turn in the ballot or sign the affidavit affirming that they do not plan to send that ballot in or count it. And at that point, it's marked in the system, and that sequence number and the ballot ID number for that ballot, if scanned in, it will not process it to be counted. It would be rejected as spoiled at that point in time, as we'd be taking the in-person vote on the voting equipment, whether it be early voting or election day. So the poll book system tracks that, and we're able to prevent dual votes in that manner.
Thank you. And since we have you here, I want to ask you again about the changes in sections 21, 40, 44, 70, and 75. Is there a way potentially to have an affidavit or something signed when somebody brings in a ballot on behalf of another? So if it's not a written statement, is there a way to track who delivers ballots on behalf of individuals outside of their family? And since we're doing written statements for disabilities, it wouldn't include that. So like if somebody came in with a number of ballots, is there a way for them, or should they be signing affidavits that they had the permission to turn in those ballots?
For the record, Joe Gloria, Registrar of Voters. Whatever the bill language dictates to us, Senator, we can implement the process. There's no reason why we couldn't do that if an amendment is made to change that language.
Thank you. That's helpful.
Senator Keycover.
Thank you, Madam Chair. I'm not sure who the right person is for this question, but I'm curious how we landed on the number of early voting locations and vote centers that we have established as the minimum standards.
Madam Chair, may I jump in?
Senator Ornschall, please.
The number here in the bill tried to look at minimum for the two most populous counties, then the least populous counties, that would be something workable, comparable to what they have done in the past, and something that hopefully they'd be able to find enough people willing to do that during the emergency situation.
Well, Mr. Gloria, how many early voting locations do you generally have for a standard general election?
For the record, Joe Gloria, Registrar of Voters. During the 2018 general election, we supported 33 sites during the early voting period. And then on election day, we supported 172 vote centers. Our plans for the general election are to actually increase the number of early voting sites to 35, 32 of which will be 14-day permanent long-term sites at government facilities, and 3 of those being mobile teams. And on election day, we have trimmed that number down to 159 sites for vote centers on election day in Clark County.
So it sounds like based on your plans for the 2020 general election, you'd be able to accommodate just about as many in-person voters that you did in 2018.
For the record, Joe Gloria, Registrar of Voters. Our concern is in the requirements that we'll have in order to properly social distance in these sites. What we would have normally been able to process at some of our sites, and I'll use Galleria Mall as an example, where we have 45 machines and 12 laptops set up, we may not be able to set up the same number of equipment in those sites, which translates to us being unable to process the same number of voters. In the last couple of days for the 2018 general, we processed between 4,500 and 5,000 voters at the Galleria Mall. It's a very efficient operation, but we can't guarantee that we'll be able to do that. And unfortunately, I can't tell the future. So there's no guarantee. We're going to work very hard to meet what the minimum requirements are in the language of the bill. If we have a spike in this COVID-19 pandemic, that's one of the reasons why I feel it's critical that we proactively make the determination to provide a mail ballot, because we are within the timeline now to work with our vendor and ensure that we can get what will be in the area of 1.2 million mail ballots sent out to our voters. If we get to the point in even middle of September or early part of October, it'll be too late to turn on a dime and get our vendor to be able to produce that number of ballots at that time. So we're going to work really hard to get the workers to support those sites. But if something happens with the pandemic that increases and we can't control, we'll at least know that we have the mail ballots in the hands of those voters.
Thank you, Mr. Gloria. What's the current deadline for a voter to request a mail ballot now? Because there's nothing that prohibits a voter from requesting a mail ballot under current law, right?
For the record, Joe Gloria, Registrar of Voters. Outside of the language in this bill, it would be 14 days prior to the election for a domestic voter to request a ballot. For the UO CABA, I believe they have until the 7th day before the election to put in their request for overseas ballot.
Thank you. And assuming this bill passes, I assume, well, let me ask, would you order all mail ballots or all ballots from the same vendor at the same time? So all of your overseas and military ballots, as well as all the ballots for all of your voters in Clark County?
Joe Gloria, for the record, Clark County. The entire voter file for the active registered voter file that we have at the time that we're ready to begin work with printing would go over. And so they would be immediately preparing to get the ballots ready for our first deadline, which is the 45-day federal overseas requirement, and then out of state at 40 days prior, and everything local 20 days prior to the election. So yes, we'd be preparing to send all of the ballots out from the beginning.
And do you have a deadline from your vendor as to when you need to get that order placed in order to meet that 45-day requirement for the overseas and military ballots?
As long as we are prepared to give them that file by the third, fourth week in August, we should be in good shape.
Thank you for that. I think finally, Madam Chair, I don't know, again, the correct person to answer this question, but in Section 8, there's discretion given, right? And it would be in the bill left up to the governor to decide whether or not to move to a all-mail election. And I'm curious as to why that discretion is given to the governor rather than the Secretary of State, who has control over elections in this state.
Madam Chair, to you and through you, to Senator from Reno. Currently, if you look at Chapter 414 of the NRS dealing with emergency declarations of disaster, those can be declared either by the executive or by our legislature. And, of course, we're a part-time legislature, meets 120 days every 2 years. And when we can't meet, the governor's the constitutional officer who has that ability. And that was why that power was vested in the governor based on, the power he has in Chapter 414. That Section 8, if the time is not right, is meant to also make sure that the election can be preserved, even if the declaration doesn't meet that minimum time before the election. I hope that answers your question. And if I didn't explain it well enough, then I'll defer to Mr. Powers. Maybe there's some more technical answer, but
well, certainly it's a choice that this body can make over who to empower with that. I guess I'll hope that in the future the governor will consult with the Secretary of State when making decisions like that.
Senator Washington.
Thank you, Madam Chair. First of all, I just wanted to make a general comment, and it's regarding some of the seniors that have to vote and have individuals assist them in filling out their ballots. Most of these individuals are their caregivers or family members. It's not usually someone that's, I would say, doesn't have any type of integrity that comes and assists these seniors. I've worked with a lot of seniors at a lot of the senior centers in Las Vegas, and like I said, most of the people have scruples and is not doing anything illegal. And most of these caregivers and relatives are trustworthy. Now, secondly, my main concern is during the primary, we did not quite have enough workers, and I want to know possibly if we're getting younger workers to work the polls, because of the COVID, a lot of the seniors wasn't able to come out and work, and they were frightened. So my main concern is that we have someone hire some younger people, some younger individuals to assist in the election process. Thank you. Well, should I say, could Mr. Glory address that, please? I'm sorry, my apology.
Okay, I'm certainly happy to answer that question. Thank you for the question. We work hard to try to get younger poll workers out at the polls. We have a program that we've developed this year where we try to motivate schools to take advantage of our Raise the Vote program, where they can actually surrender their pay and put it towards buying uniforms for the band, student council, winter ball dance, prom, whatever they want to put that money to. We've been working that, and so far we've been, I believe, successful in the last report to getting a little over 300 people to participate in that program. We've also networked with the Clark County School District representatives that we regularly work with. We have an outstanding relationship with them. They send out through their interoffice mail notices from us to the teachers, to student council leaders, various groups from the high school level to try to motivate them to get students to work the polls. And because of the relationship we have with CTSD, they've always partnered with us, at least for the past 20 years that I can remember, that we don't have school on election day in November. So it's a perfect opportunity for students to get out. Some of them can earn volunteer credits while they get paid for scholarship requirements, admission to college, things along those lines. So it is definitely something that we work hard to try to motivate younger poll workers to participate in the process.
Madam Chair, my next question is, with the schools having issues also with COVID, is there a possibility you can go to the university or either go to the community college to try to recruit some of those college students?
Joe Glory, record registrar of voters. Although the effort isn't the same with the colleges as it is with the high school level students, we do reach out to them. We reach out to sororities, fraternities, alumni group. We have a direct relationship with UNLV and also the College of Southern Nevada. Because we vote there, we're very fortunate in that we have contacts with the people who deal with student relations there. And so it's not as big an effort as we put into trying to recruit the high school students, but we do also reach out to all of the colleges here locally to motivate them to try to get out and work the polls for us.
Senator Ratty.
Thank you, Madam Chair. So I want to follow up on a prior line of questioning because I'm a little bit confused myself. So I'm looking at section 19, subsection 3. So there's been a lot of conversation about people assisting somebody who is in need of assistance with their ballot. Again, we've been in many elections past, whether that be an absentee ballot or an in-person situation. I think we strive, and it's a noble and important effort to make sure that everybody has access to vote regardless of their ability, and so we provide supports so that folks can do that. I think at a minimum level we need to stay in compliance with the American with Disabilities Act, but this is something we've been doing for years. So I'm a little bit confused as to why there's so much concern about that, but it explicitly says in the bill, unless I'm confused, that if you help somebody fill out their ballot, that you have to note that, and you have to submit a written statement. So am I missing something? Are we changing that in any way in this particular process, or is it pretty much the same thing, and we're very, very explicit here, where if you're going to help somebody fill out their ballot, that has to be noted on the ballot, and you have to write a statement?
Thank you, Madam Chair. For the record, Kevin Powers, LCB Legal General Counsel. I think the important distinction to be made, and there's been a blurring possibly of the two different acts. Section 19 deals with assisting a voter who meets the qualifications, has a physical disability, is 65 years or older, or is unable to read or write, actually mark and sign the ballot. Either you mark and sign it on their behalf, or you assist them and mark and sign it. That's when you have to file the affidavit. However, Section 19 doesn't control return of the completed mail ballot. That's what Section 21 does. So even if you assisted the voter fill out the ballot, you may not necessarily be returning the ballot on behalf, but your assistance has to be documented in the mail ballot by including the written statement. If you were to return it on behalf of the voter, then you'd be subject to Section 21. Section 21 applies to any person who returns a mail ballot on behalf of any voter. There's no qualification. It's not a disability. It's not an age limit, or it's not the inability. Right. So if you conflate the two, then you can get into the confusion that somehow they're the same thing, but they are different.
Great. Thank you for that clarification. So it's only in the act of assisting somebody with a ballot that you may know something about the content of that ballot, and then therefore we want to know who you are and have that on record so that if there is some sort of problem with that person's ballot or the secrecy of that ballot, we know who we should be talking to. So then with the delivery of the ballots, then those ballots are subject to all of the rules that make a ballot legitimate as they were in the primary mail-in or absentee ballots today. That I'm assuming that envelope needs to be sealed, it needs to be signed properly, it needs to be all those things so that we know that when the ballot left that voter's hand and was delivered to the registrar and turned in, that ballot is still intact and has not been tampered with or messed with in any way. Is that correct?
Thank you, Madam Chair. For the record, Kevin Powers, LCB Legal. That is correct. And I should also emphasize that a lot of the language in Section 2 to 27 with regard to the procedures of signature verification and handling ballots is in existing law with regard to absent ballots. And that is why the later sections of the bill have identical language in all those other areas so that there's consistency in all the procedures for returning all types of mail ballots, whether under 2 to 27, absent ballots, or mail-in precinct ballots. So yes, a lot of what you see is already done, and if you return a mail ballot, all those mail ballots are subject to all the same signature verification requirements and other requirements to assure that the ballot is the voter's ballot that exists now under NRS chapters 293 and 293C. They're just now incorporated, refined, and made uniform across all of these various sections.
And we did, in fact, pass legislation that allowed for that right to have a mail-in ballot by right. Like anybody can do that today.
Thank you, Madam Chair. For the record, again, Kevin Powers. In the form of an absent ballot, yes, someone can make a request for an absent ballot. If they are a eligible voter, then they will be issued an absent ballot as long as the request is timely made before the election. Or if it misses the deadline, there's certain other emergency circumstances where you can get a absent ballot up to the day of the election. So yes, there are existing provisions that allow not only you to obtain the absent ballot, but actually allow someone to help you fill out that absent ballot as well if you meet certain criteria, like in the bill, you have a disability or 65 years of age. Thank you.
So then, therefore, what this bill does is in the period of a pandemic, and I've been sitting here reflecting, and maybe I live with this a little bit too much every day given my line of work, but I was looking at the Washoe County results again today for COVID, and we've got 3 additional deaths. Our rate of transmission is at record highs. The number of cases that we have in the community, the average every single day of how many new cases that we have over that 7-day rolling average, like the trends are not heading in a good direction. And so what this bill does then is make sure that every single voter has the opportunity to use that same process, a process that we've already been using, a process that's been vetted, a process that we know works, to make sure that we reduce the number of individuals, or we make our very best effort as a state to reduce the number of individuals who will be at risk of transmitting a virus that we know is capable of killing people, particularly vulnerable populations. And the longer that you have the contact, the more likely that you are to have transmission. And so if we have people standing in line, and while we would like to believe that people are going to follow social distancing guidelines, I think if we've learned anything in the last 5 months is that people don't always follow social distancing guidelines. They don't always use hand sanitizer. They don't always do all of the things that we've been asking them to do in their very best interest. So what this bill does is it gives that opportunity for every Nevadan to stay safe and mail in their ballots. And even if every Nevadan doesn't choose to do that, it still leaves the choice for you to go to a voting center or to vote early or to use other alternatives, as the CDC recommends. It hopefully reduces significantly the amount of people who are congregating and putting themselves at risk of transmitting this virus. Essentially, it uses tools that we've already put in place, but just makes those tools available to everybody in order to save lives. Is that basically what you're asking for, Mr. Gloria?
Joe Gloria, Registrar of Voters for the record. Yes, ma'am.
Thank you.
Senator Spearman.
Thank you, Madam President. I'm a little bit disappointed right now, but let me begin with a couple of names. Viola Liuzzo, Michael Schwerner, Andrew Goodman, James Chaney. We don't know their names independent of an incident that happened in Mississippi, but these were 4 people who, 3 of them were white, and 1 was a local African American. The only thing they were trying to do was register people to vote. I was very, very young, but I do remember the news account of 4 little girls in Birmingham who were killed. I remember asking my mom, why did they get hurt at church? And my mom said to me, there's some people that don't want colored people to vote. And this was trying to send a message. 70s, 80s, 90s, all the way up to 2004. To the best of my recollection, we didn't have, we never had any concern about voter fraud, but it was in 2009 that we heard about, quote, rampant voter fraud. Maybe it was just a coincidence that in 2008 Barack Obama was elected president. I don't know. I'll just say that that line, that theory, was birthed right about that time. A lot of the things that we're talking about here Mr. Gloria, you said that we already have them in place, which means that they were in place in 2014 in that election. Is that correct? Mr. Gloria?
Joe Gloria for the record. I'm very sorry, Senator Spearman. You broke up on my connectivity here. Can you just repeat that last piece?
So I'm following up on my colleague's statement that the only thing that we're doing is making what's already in law available to everybody. So these provisions that are currently available to people who are absentee, and by the way, is there a difference between absentee ballots and mail-in ballots?
Joe Gloria for the record. Not previously the way we handle them. It's a tally type that we call absentee, but the language in this bill does define them separately, absentee and mail.
Yeah, and I guess what I'm saying here is that there's a process that has already been perfected for absentee, and so this isn't some apple that fell off the tree from Mars, and we're already doing this. It was in place in 2014. The absentee ballot was in place in 2014. The same procedures were in place in 2014. Is that correct?
Joe Gloria for the record. Yes, Senator, that is correct.
Well, then it's a good thing that you all know how to do your job, because in 2014, that's when our Secretary of State was elected. So apparently you got that right. The other thing, I'm going to take issue with my colleague from Senate District 20, who maybe it was not intentional, but this is what I heard, casting aspersions on people who, quote, vulnerable and live in some communities as may not, quote, be as sophisticated, I think. I take issue with that. The other thing that I want to say is that for some of the people for whom this will now be an option, many times in the military, when you move, whatever mail was sent to you doesn't necessarily follow you. And we very well could have active military people who were supposed to be going to Bahrain, but then 3 days before they left, they got orders to come to Nevada, and they're already a citizen. They are a citizen of Nevada. Driver's license, pay their taxes, their vehicle taxes in Nevada, all of that. But if they were not disabled or 65, then this may not have been available to them. The other thing is, I'm not sure how many people understand that this has taken place in our veterans' homes in northern and southern Nevada, because we have veterans who are now infirmed, who served their country, by the way, and served it honorably in World War II, Korea, Vietnam, the Gulf War, all through the Cold War. And we also have some people who are veterans that are under the age of 30, and they are disabled because they had the misfortune of riding over an IED. They're disabled. Excuse me if I seem impatient, but I'm sorry, I've heard this before in other ways. And oh, by the way, if I go back to those 4 little girls, they would be in their 70s and 80s right now. And I'll be willing to bet you they would be glad to have someone help them with that ballot. The Bible tells us, as someone thinketh in their heart, so are they.
Senator Ornschel.
Thank you very much, Madam Chair. And a couple of questions for Mr. Gloria, and then with your indulgence, I have a couple of quick questions for Mr. Powers. Mr. Gloria, in the bill, the section that allows someone to return a ballot on behalf of someone else, under your system, in Clark County, the system used in the primary, if someone asked for help to get their ballot turned in, they can track that online. They could see if it didn't get turned in. Is that correct?
For the record, Joe Gloria, Registrar, that is correct. All of the ballots that are processed in Clark County, when they log into Registered Voter Services, they can check it on their own, or It's as simple as making a call to the office and asking one of our clerks to check it for them.
So, if this bill does become law, and if I need someone to turn in my mail ballot because I, for some reason, am too sick to get to a post office or too sick to get to the stamps, and I have a neighbor or a friend who's willing to turn it in and drive it down to the election department, and I can check and see if it didn't get turned in, and that person, hopefully it's just an honest mistake, hopefully there's no criminal intent, but there's a Category E felony hanging over their head. So I think there's a pretty strong penalty there if they were to not follow through with that. One question I have, I think you talked a little bit about some of the challenges recently that you've had in terms of finding private locations for early voting. I know in the past, it was convenient. You'd have them in grocery stores around the valley. Could you talk a little bit about some of the challenges you've had finding those early voting sites at places like grocery stores and malls, things like that?
For the record, Joe Gloria, Registrar, Clark County. We wanted to proactively put together a plan, Senator Orenshaw, that would prevent anything from happening late in the election process that would affect our early voting schedule. So we can't control what privately owned businesses do. And although we've had a fantastic relationship with Albertsons, Bonds, La Bonita, all of the supermarkets that support our early voting programs here, we didn't want to be put in a position where if we had a spike in the pandemic, they became uncomfortable with us voting and their location. The same falls true for three of our most popular sites that have the longest history of voting, the Boulevard Mall, Meadows Mall, and Galleria Mall. So we won't be voting indoors there. We've set up voting tents that are, if you're from Clark County, you're pretty familiar with what we've done to provide access all over the county, and just on a hard surface that gives us ADA access. So we proactively redid our early voting schedule, took it to the county commission, and they approved it because we can't take the chance that things will get worse, and then we have privately owned facilities deny us access to their facilities. So we're now focused on government facilities, schools, to provide our in-person access for the most part. I would say 95% of it.
Thank you very much, Registrar Gloria. And then one last question I have. As you have tried to recruit poll workers, I know that that's been a challenge through the years, but now with the pandemic that our country and our world's facing, have you found that a lot of folks who worked the polls in the past have been hesitant to come back, have been hesitant to be at an in-person polling location? Have you found that that's become a new challenge for your office?
Joe Gloria for the record, Clark County. Without a doubt, Senator Orenshaw, it was always tough to get workers to work the polls, but now in particular, especially our older poll workers, they're not as willing to serve. We have seen in our recruiting efforts through the month of July that a lot of the people that have had a history of working for us at the polls are beginning to come back. We're hoping it stays that way. We do have a full slate of training that's scheduled for the next 2.5 months. Actually, our training starts on Monday. So we'll have to monitor that. My management has committed, and so the commissioners, to doing whatever they need to do to make sure that we have the resources in place, but none of us can tell the future. So we're going to do our best to make sure that we come through with exactly what we've told the general public that we're going to provide, but on all of our schedules, we're going to list that the schedules could change contingent upon anything that had to do with the COVID-19 virus.
Thank you. I can see that creates a lot of uncertainty for you, for the office, and for the election. Madam Chair, with your indulgence, I have a question for Mr. Powers. Mr. Powers, looking at Section 19, in terms of the person who assists someone who's disabled or over 65 years of age to mark their ballot, I don't see any specific criminal penalties here. I do see that the person has to sign a form or make a statement attesting to their assisting the voter. But even though there aren't any penalties here, if that voter were to somehow believe that the person had coerced them, bullied them, perhaps tried to change their vote when they'd been told to vote one way, are there not other sections of the Nevada revised statutes that might subject that person to a criminal prosecution, whether it's for forgery, coercion, elder abuse, offering a forged document to a public agency? Aren't those possible penalties that someone who did that would be subject to, even though they're not here in this bill? They're there. Is that not correct?
Thank you, Madam Chair. For the record, Kevin Powers, LCB Legal. That is correct, Senator. There are criminal penalties for criminal acts at the end of Chapter 293 of NRS. There's a series of prohibited criminal acts, criminal penalties associated to them, with penalties ranging from misdemeanors to Category E felonies. In addition, if the act itself qualified under any other criminal statute, like you said, fraud or elder abuse, that too would be criminally prosecutable. So yes, there are existing penalties both under ordinary criminal law and NRS Chapter 293 to prohibit certain criminal acts involved with taking advantage of elderly or disabled individuals. Thank you, Madam Chair.
Thank you, Mr. Powers. Thank you, Madam Chair.
Okay, thank you. Thank you, Mr. Powers, Mr. Gloria, Secretary of State Sagowski, and Mr. Thorley for being with us today and answering all of our questions. We definitely appreciate it, and thank you for being with us. We are going to go ahead and move to the public comment of our agenda item on Assembly Bill number 4. This item, for those of you who have been joining us, will allow for public testimony by phone. You can refer to the committee's agenda for the directions on the dial-in. Once you dial in, you'll be entered into a queue of other callers who are waiting to testify. And you must, of course, stay on the line until it is your time to speak. Otherwise, you will lose your place in the queue. Because of time considerations, each caller offering testimony during this period of public comment will be limited to not more than 2 minutes, and I will jump in once you get close to that 2 minutes and ask you to go ahead and wrap up. The lines are now open for public testimony, and I will note that we will be taking public testimony the same we have as earlier today, which is we will do 30 minutes of support testimony, 30 minutes of those in opposition, 30 minutes of those in neutral, should there be people wishing to speak in those amounts of time. For those of you who are wishing to give some additional testimony or who are not able to give testimony on the phone, we of course will take written comments, and those will be added to the meeting on the legislative website in lieu of testifying. Again, the email address for that as well is on our agenda, and we are going to go ahead and turn it over to our Legislative Council Bureau broadcast staff. We will start with those who are in favor of Assembly Bill number 4.
If you are in support of AB 4, please press star 9 now to get your place in the queue. Caller with the last 3 digits, 056, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Actually, I pressed star 9 instead of star 6, so I was going to press neutral on the bill. I wanted to ask, will there be any hearings before the elections on hydroxychloroquine in Nevada? And what's the state of the direction from the U.S. FDA on that chemical drug that's been used for 60 years for malaria and wasn't noted as being dangerous to people's hearts until just this year? And that's my basic concern. I don't know if you could all postpone this vote until next week so that people can know about the vote, that citizens of Nevada can be informed. I understand that this is a vote that was decided on today to be taken up tonight. It would be more democratic to have the people of the state of Nevada aware of this particular vote. I hope you all make the right decision. I don't personally know which decision that is, which should be right, but I want you to work from without hysteria and with more information about drugs that can help. Without the information that I've been getting, which seems to be very confused with frontline doctors and the FDA and BARCA, all kind of not really knowing what to do with what to report about hydroxychloroquine in a clear manner. I'm done with my testimony, so give somebody else some time.
Thank you. We will go ahead and launch that with neutral testimony. Again, I would remind everyone who's joining us, we are going to do testimony in support. So please listen carefully to the instructions from our broadcast staff who've been able to help us facilitate this public comment. We're in support, then we will do opposition, and then we will move to neutral after that.
If you are in support of AB4, please press *9 now to get your place in the queue. Caller with the last three digits, 130. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, Christine Saunders, that's Christine here on behalf of the Progressive Leadership Alliance of Nevada. Some of you may know that I grew up in Oregon, a state that has been vote by mail since 1987, and has time and time again shown that vote by mail increases turnout and is not fraught with fraud. My 18th birthday was just days before a presidential primary. I remember completing my ballot alongside my mom, where I could ask her questions about the process, and then we simply took the ballots down the block to our county library, which had a ballot drop box right outside. In 2008, Plan held Get Out the Vote events at many of the tribal polling places and sought to bring the community together to make voting a part of their tradition. As tribes have been disproportionately impacted by COVID-19, it is essential to extend the deadline to request polling places and allow people to turn in ballots for others. Many homes on the reservations do not have mailboxes, requiring that individuals travel to a P.O. box, which often means mail is not checked or sent every day. During the primary election, we had a number of tribal members request support for returning their ballots, but were unable to offer them a solution. By removing the restrictions to return ballots, everyone will have the option to have someone they trust return their ballot for them. No one should have to choose between their health and voting. No one should have to choose between staying in line to vote or to make it to their job on time. No one should have to choose between violation of their tribal lockdown orders and exercising their right to vote. AB4 is a common sense solution, and we urge your vote in favor. Thank you.
Caller with the last three digits, 077. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
For the record, this is Lindsay Harmon, LINDSEYHARMON, and I'm the Executive Director of Planned Parenthood Votes Nevada. Our organization is strongly supportive of AB4 as it ensures voters will be provided with the opportunity to vote by mail, as well as providing increased polling places and ballot drop boxes. Because of the pandemic and the unprecedented challenges to the Nevada voting system, the legislature must take action to ensure that eligible voters are able to exercise their right to vote by continuing to allow for vote-by-mail elections, ensuring that all active registered voters will automatically be sent a mail ballot. Nevadans should not be forced between risking their health and exercising their fundamental right to vote. This body must implement real solutions that will protect election integrity and the health and safety of Nevadans. The voting process must remain transparent and adaptive for voters as we work to make every vote count in this election. Thank you.
Caller with the last three digits, 201. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
For the record, my name is Emily Prasad Zamora, EMILYPERSAUD-ZAMORA, and I'm the Executive Director of Silver State Voices and concerned about November. I'm calling in support of AB 4 because we have 95 days until the November election to make sure that all Nevadans can cast a ballot in a way that's safe and accessible. For the June 9th primary, my organization ran an election protection program where we stationed nonpartisan volunteers at vote centers to assist voters and be our eyes and ears on the ground. What we saw and heard was unacceptable. Voters waiting 6, 7, 8 hours to cast a ballot. Mothers with their babies waiting past midnight, and the last voter casting his ballot at 3:08 a.m. the next day. Currently, Nevada has no protocols on how to handle elections in the case of natural disasters or states of emergencies like COVID-19. And AB 4 provides that direction for our Secretary of State and registrars to administer elections in these circumstances. Nevada voters need multiple mechanisms to participate in their right to vote. This means sending a mail ballot to active registered voters with paid postage, extending the deadline for tribes to request a polling location, providing flexibility for our county registrars to start counting ballots sooner than 4 days before election day, and removing the penalties on submitting mail ballots so that tribal leaders can make decisions for their communities without having to risk COVID, and increasing the amount of vote centers. A few weeks ago, we lost the voting rights champion, Representative John Lewis, who faced threats to his health and safety when he walked the Edmund Pettus Bridge in Alabama just for the right to vote. 55 years later, we can't ask voters to do the same, to risk their health and safety for the same right to vote. Representative John Lewis was a champion for all of us, but you can also be voting rights champions for the state of Nevada by voting yes for this bill. Thank you.
Caller with the last 3 digits, 066. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening. For the record, my name is Guillermo Barahona, GUILLERMO BARAHONA, and I'm calling today in support of AB 4 because we need to make sure that Nevadans are able to cast their ballots safely and accessibly in November. As the Civic Engagement Director at CHISPA, my work is centered on making a difference in the civic life of our community by developing a combination of skills and traits that will make a difference in the lives of our residents. I believe that in a thriving community, folks must take an active role, and they can do so by casting their ballot. Voting allows everyone to develop and use their knowledge, skills, and voice to cultivate a positive change in their communities. COVID-19 has impacted all of our lives severely. Graduates are unable to walk, children are unable to go to school, and many, many folks have lost their jobs. There are so many implications of the virus, but voting should not be one of them. A lot of voters are unable to wait in line to cast their ballot, so they rely on vote by mail. However, there needs to be ballot drop-off locations in Clark County. Voters shouldn't have to drive an extended period of time just to drop off their ballots. I am heartened to hear that Clark County intends to provide multiple drop-off boxes. But of course, as our elected officials, it is your responsibility to ensure that voting is more accessible and safe for Nevadans by mandating at least one ballot drop-off location in Clark County. Thank you.
Caller with the last 3 digits, 831. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is Adrienne Michelson, ADRIENNEMICHELSON, and I'm here on behalf of myself. I live in Senate District 9, and while I don't work in politics currently, I previously have 6 years of experience working on statewide campaigns, particularly for Democratic candidates. And my public comment is while in support of this current bill, I want to kind of clarify what I've heard from Republican colleagues in the Senate chambers, implying that there are rogue elements all about trying to, harvest ballots, quote unquote, in a way that would, endanger someone's personal, vote. Having been a data director for a presidential campaign within the state of Nevada, and also having been working on data and field in states like Ohio, I'm confident that any Democratic political campaign would never want and expect that each organizer that they send out to talk to people, to get them to register to vote, to get them to go out and cast a ballot, is done so with integrity and compliant with the law. Anything else would be a fireable offense, and not to the standards of any Democratic campaign that values getting people turned out to vote. That being said, I want to remark on Eric Hansen's comments, thinking that, you know, people go out intentionally to vulnerable people and try to particularly extort data relevant to getting their voter information. From my experience, having knocked on doors and turned out voters, it's been people who seriously need help, particularly in the state of Ohio, people who seriously need help, who have struggled to get ballots in before, who have heard misinformation online, trying to get them to just turn in a ballot regardless of their political preference. That being said, data campaigns...
If you could go ahead and wrap up,
data,
please.
Yeah, sure. Campaigns are based on data. It's most likely that Democrats are going to try to turn out other Democrats, which is public information. So I support this bill. I don't think it's going to harm the integrity of an election to ask everyone to vote by mail during a pandemic.
Caller with the last three digits, 831. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening. My name is Cecia Alvarado, CECIA-ALVARADO. I am the Nevada State Director for Mi Familia Vota. I'm testifying in support of AB4, as it will ensure that Nevadans can safely cast their ballots in November. The coronavirus pandemic has disproportionately affected the Latinx community here in Nevada. This pandemic has changed our lives, and we need this bill to ensure all communities can safely vote this fall. With older Latinx at highest risk of COVID, we need mail ballots sent to register voters automatically. I especially want to uplift the part of the bill that allows signature assistance. As director of the voter on their mail ballot, for those older Latinx and Latinx with physical disabilities, this will make their voting experience much easier. We must pass this bill because we need to make sure that all voters can cast a ballot. People with disabilities should not be disenfranchised and should be allowed to have assistance to mark and sign their ballot. I ask this body to please support AB4. Thank you.
Caller with the last three digits, 577. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Chris Daly, CHRISDALY, Nevada State Education Association, the voice of Nevada educators for over 100 years. NSEA supports AB4 to ensure both vote by mail and sufficient in-person voting options are available during elections impacted by emergencies or disasters. Educators ask students to use their voices and build their own agency. We believe our politics and electoral system should strive for greater enfranchisement because every person and every vote is important. The National Education Association has a long and rich history supporting greater democracy. From past NEA President Charles Ormond Williams' efforts to get Tennessee to ratify the 19th Amendment in 1920, the students affiliated with the California Teachers Association who started the campaign to extend the vote to 18-year-olds back in 1967. With COVID-19, everything has changed. But we believe that given these circumstances, AB4 is both measured and also fits well into the historic effort for greater democracy and participation. It's a good bill. You should pass it. Thank you.
Caller with the last three digits, 155. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Madam Chair and members of the committee. For the record, my name is Christy Cabrera, CHRISTICABRERA. I'm here on behalf of the Nevada Conservation League. We believe that the long-term health of our planet is linked with the health of our democracy. Passing strong laws to protect our environment depends on open and fair elections. It is time for our state to embrace vote by mail as an option for Nevadans who want to cast their vote, but also stay home and stay safe. This bill will provide a safe way for voters to turn in their ballot while providing the proper voting security through a signature verification process. If a ballot does not have a signature, or if the signature is questionable, the county clerk will contact the voter through multiple means of communication, including mail and telephone, as well as text message and email if the voter has provided that information. The voter has until November 10th to provide signature or confirmation. It is critical that every vote counts, and we believe that in a time of uncertainty due to COVID-19, the reforms of this legislation will ensure that every Nevadan's voice is heard on Election Day. We urge your support. Thank you.
Caller with the last three digits, 576. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, for the record, my name is Eric Chang, ERICJENG. I'm currently the Director of Outreach for Asian Community Development Council. We are a 501c3 nonprofit serving the Asian and Pacific Islanders in the state of Nevada. Senators, I urge your support for AB 4 because there's a critical need to expand and increase the number of vote centers for Clark County and the state as a whole. Voters should be able to travel to a nearby and convenient vote center without a significant burden on their time and resources. I urge your support for AB 4 because during the June primary, I was one of the volunteers that stood from 7 a.m. until 1 a.m. to help voters until the last voter at Desert Breeze Community Center cast their ballots. People love to mention that the last voter at the Paradise Community Center was an Elvis impersonator. But not known as for Desert Breeze, the last voter in line was a young Chinese American woman, and we got to talk for the time that she was there. She waited 6 hours not because she had nothing better to do that day, but because it was her very first time voting. She understood the stakes at hand. She understood how much sacrifices it for her to be able to make that vote. She understood the sacrifices like Senator Spearman just mentioned, all the civil rights movement that led to this point. She also understood the sacrifices that her family made for her to be able to immigrate to America. It took 5 years for her green card and naturalized to be a U.S. citizen. She understood what's at stake. She understood that she will be the first in her line of family to be the first to cast a ballot to elect who should represent her. This is what we are here for. This is America. This is what we pledge, not the Voting Privilege Act, nor the Voting Challenge Act, but the Voting Rights Act. Senators, I urge your support for AB 4 to secure the access for voters by increasing vote centers that observe social distancing and CDC guidelines during early vote and election day.
If you could go ahead and wrap up.
And we can do better for our state. Please support and pass AB 4. Thank you.
Caller with the last three digits, 755. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Marlene Lockard, Lockard, representing the Nevada Women's Lobby. We urge your support for passage of AB 4. We feel that it is essential in this extraordinary and very difficult time to ensure the safety of all Nevadans. We hope you will vote yes. Thank you.
Please slowly. Caller with the last three digits, 983. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is William. Hi, sorry. My name is William Ledford, WILLIAM LEDFORD. I am the Director of Advocacy for Lutheran Engagement and Advocacy in Nevada, representing the ELCA churches in our state. Our organization and our denomination have both historically supported any and all efforts to enfranchise as many people as possible. And especially in a time like this where the polls are difficult or unsafe or whatever the case may be, but the burden of voting right now weighs heavier on some demographics more than others. and we find an issue with that. And we think that this bill will help everyone have an equal chance to their right to vote. Thank you.
Caller with the last three digits, 397. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening, Madam Chair, members of the committee. For the record, my name is Matthew Kimball, Matthew Kimball. I want to urge you to support AB 4 for the reasons mentioned above, as well as the fact that this bill will increase our access to voting this election cycle, which is critical, as it is every election cycle. As someone who's worked very hard to make sure folks are registered to vote, know where their polling location is, and know all of their opportunities to cast their ballot, I believe this bill is critical to our success in this upcoming election. Thank you so much, and I urge you to support this critical piece of legislation. Thank you.
Caller with the last three digits, 541. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
J.D. Klippenstein. It's spelled Jdklippenstein. Hello, Senate Committee of the Whole. my name is JD. I'm the Executive Director of Action, a grassroots community organization in Washoe County. And I'm calling in support of AB 4. Our organization is deeply committed to building a strong and inclusive democracy that actively engages all citizens. To that end, we have registered thousands of voters since the fall of 2019. And we've seen firsthand the barriers that disenfranchised communities face when it comes to voting. COVID-19 has only increased those barriers. We believe a healthy democracy is a key part of our recovery from COVID-19, and this is the main reason we support AB 4. We need our general election to be all mail-in, just as our 2020 primary was. And in addition, in Washoe County, we need a significant increase in polling locations and ballot drop-off locations. We believe that these increases will give the options our neighbors need to ensure that they're able to vote in the ways that they're both safe and comfortable with. So please take this time to support Nevadans and our democracy by voting yes on AB 4. Thank you for your time and consideration.
Caller with the last three digits, 723. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening. My name is Brianna, Briana, Escamilla, Escamilla, and I'm the Nevada State Director with the Human Rights Campaign. I'm calling in support of AB 4 because nobody should have to choose between putting their health and the health of their families at risk and their constitutional right to vote. During the June 9th primary, HRC staff and volunteers supported election protection efforts by working as poll monitors. Since there was only one vote center in Washoe County, voters had to wait in line for long periods of time in order to cast their ballots. The average wait time was around 1 hour and 40 minutes, but many folks had to wait in line for up to 3 hours. During any election, this would be challenging, but especially during a global pandemic when voters were worried about protecting their health. During our Get Out the Vote efforts, we spoke with voters who did not receive the ballot but also were uncomfortable with voting in person because they were in an at-risk population. These voters were truly disenfranchised and had to accept the fact that they were going to be unable to vote. This is unacceptable. Nevadans need AB 4 because voting should not cost anyone their lives. Voting should not take several hours. Voting should not be a significant burden. Voting should be safe and accessible, and we can make sure that that happens by providing Nevadans with multiple voting options this fall. We urge you to vote yes. Thank you for your time.
Caller with the last three digits, 695. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Excuse me. Good evening, Madam Chair. My name is Holly Wellborn, HOLLY, I'm the Policy Director for the ACLU of Nevada, testifying in support of AB 4. This is a decisive moment for the state of Nevada. November will be upon us before we know it, and this bill ensures that Nevadans can safely participate in our democracy by providing robust voting options. This moment also requires that we act with urgency. According to a report from the Center for Public Integrity, Nevada is in the red zone, which means we have more than 100 new COVID-19 cases per 100,000 people per day. We cannot figure out how to protect our election during this pandemic. If we simply revert to the status quo, communities may be forced to choose between their health and their vote. In this moment, vote by mail is critical for election access. Sending a ballot to all registered voters guarantees Nevadans do not have to gamble with large crowds. Long lines at voting locations violate the fundamental right to vote. This bill will reduce election day crowds and waiting times by opening up more in-person polling places for those who are unable to vote by mail or who need to register on election day. 8-hour wait times are simply unacceptable. Nevada must also deliver solutions for the state's 27 tribes who may not have traditional mailing addresses or nearby post offices. Nevada will face more challenges before this pandemic is over, and asking these practical solutions to protect our right to vote can only make our democracy stronger. We strongly encourage you to vote yes on this bill. Thank you.
Okay, and we are actually going to take one more caller and support, and then we'll be at our 30-minute time frame, and we'll move to opposition.
Caller with the last 3 digits, 750. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Beverly Harry, Beverly Harry. I am providing testimony for support of AB4. To my knowledge, we are still in a pandemic and the virus has not disappeared. It is the responsibility of legislators to protect every Nevadan from a very contagious virus. Today, 48,150 confirmed cases have been reported, 831 deaths, and 38,000 recoveries. It is my opinion, if state public health directors direct people to boil water to remove a pathogen, the public follows the health direction. And if we're told the fact that the coronavirus are contagion, it is the science to make a recommendation to the state public health director to protect the health and welfare of the public. Legislators do not qualify as the virologists here, and every attempt to overstep that role is a violation of the oath you have taken. We do not know what the viral caseload will be on election day. Therefore, you must make a decision for the protection of public health and keep every voter safe. When COVID hit in mid-March, the safest place we were that we could be was in our home. It is still the safest place to eat, sleep, to be schooled, and work. If the state has not made the decision to fund internet access within tribal lands or rural communities and has not made voter registration accessible to tribes, then we are at a crossroad again with voter disenfranchisement. Common sense decisions need to be made by the Secretary of State to ensure all voters have a safe environment in which to vote. A vaccine appears not to be available by November 3rd, 2020. As tribes continue to be in lockdown and have tribal imposed curfews, it is imperative for tribes to utilize the tribal and county police to transport ballots on the day of election. Further, voting at the precinct only can be considered a violation of the Voters' Rights Act. I know that a state of emergency.
If you could please go ahead and wrap up. We're just over the 2 minutes.
Okay. Please vote in favor for AB4.
Okay, thank you. We will now move to opposition. If you are in opposition, please make sure that you listen to the instructions, and we'll go ahead and begin testimony in opposition.
Callers in opposition to AB4, please press *9 now. Get your place in the queue. Caller with the last 3 digits, 898. Please slowly state and spell your name for the record. You have 2 minutes and may begin. Sorry, Madam Chair, they dropped off. Caller with the last 3 digits, 304. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is Jim DeGraffenreith. I am the Vice Chairman of the Nevada Republican Party. My name is J-I-M, last name D-E-G-R-A-F-F-E-N-R-E-I-D. We stand in strong opposition to this bill. This bill is presented as a way to improve safety and access to voting, but if that's what it's about, then it's entirely unnecessary. The state of Nevada already has one of the most extensive processes anywhere for allowing any voter who is concerned about the safety of voting or for whatever reason doesn't want to vote in person to be able to safely vote at home. Yet many of us observed the disenfranchisement of voters in our primary election. While the proponents of this bill refuse to disclose how many ballots could not be counted in our primary elections because they were deficient in some way, we know from talking to voters and hearing testimony earlier this evening in the Assembly that many voters were not counted because they had errors. Joe Gloria testified earlier that many of these voters could not even be contacted to cure their vote because they had failed to sign their ballot or even sent the envelope while forgetting to put the ballot inside. Had these voters cast their ballots in person at a voting machine, their votes would have been counted, not thrown away. And that's not a partisan issue. Democrats and Republicans are equally able to make mistakes in an unfamiliar process that will disenfranchise them. It's been argued that forcing all voters to mail in their ballots will eliminate the long lines experienced in our primary election in Clark County. Yet we know that those long lines were in fact caused by the complete and absolute failure of Clark County to handle an all-mail-in election in a timely way. And recall that that was an election with only 30% turnout. The unprecedented and unacceptable hours-long lines experienced in our primary election should instead be a warning to us that we need to return to our traditional combination of mail-in and in-person voting, which Clark County has proven that they can handle. This bill is a solution in search of a problem. Our existing system allows everyone who is comfortable doing so to stand in line with masks and social distancing and cast a secure, secret ballot on a voting machine while allowing those who feel that they are endangered by in-person voting to vote safely and securely by mail. We urge a no vote on this rushed and flawed bill that will disenfranchise Nevada voters, whether they're Democrat, Republican, or nonpartisan. Thank you.
Caller with the last three digits, 634. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Daner Bailey. That's spelled D like David, A-I, N like Nancy, E-R, B-A-I-L-E-Y. Your job is to protect our rights and not our health. The left has repeatedly claimed that voter fraud doesn't exist, but members of ACORN were prosecuted, as have many others, for voter fraud in this state and many others. If people are afraid of COVID or disabled, let them absentee vote. Otherwise, if they can go to Walmart, a casino, or a protest, they can take themselves to the polls. Voting is a civic duty, and laziness shouldn't be a valid excuse. If a voter wasn't able to vote in a timely manner, that's between them and whoever's in charge of their polls. It shouldn't give license to compromise the integrity of an election. The Attorney General in this state is a Democrat who didn't know the definition of larceny. I feel that he won't know what voter fraud is or be willing to prosecute it if it was discovered. I keep hearing about how it's against the law to tamper with ballots or commit voter fraud. It's also illegal to murder or deal drugs, but criminals do it. This bill does endanger the integrity of the election, as there's nothing in place to assure the mailed-in ballots are legitimate. I'd also like to remind the people who have spoken of a democracy that the United States is a constitutional republic and not a democracy. Their failure to understand this explains a lot of what's wrong with this country today. Finally, I'm fed up with elected officials forcing rules down our throats by circus act moves designed to eliminate public action in the legislature. I urge you to oppose this. Thank you.
Caller with the last three digits, 842. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is David Gibbs, D-A-V-I-D, G-I-B-B-S. If people can stand in line at grocery stores and other businesses, we can do the same thing with voting locations. We've got over 3 months to figure it out and make the necessary preparations. They can be made safe for all. For those who would still feel uncomfortable to vote in person, the process already exists for them to get a mail-in ballot. There's no need to change anything. We already have an inclusive democracy. Every eligible person who wants to vote is able to do so. Everyone already has access to the ballot by mail-in or in person, regardless of demographic, and this bill doesn't change any of that. In the June primary election, I read that approximately 10,000 ballots were declared void due to invalid or illegible signatures. That's more than 2% of the ballots cast. With an expected 80% turnout in November, that could mean over 25,000 ballots could be voided. That's enough to change the outcome in many races, including the presidential race. And some of you senators who are running in tight districts, that could have a significant impact on your race. This would not happen with in-person voting. It will take over a week to resolve signature problems and to count all the ballots in mail-in election. That's what happened in the primary with only a 29.5% turnout. We expect to have almost 2.5 times the number of ballots in the general election. I don't have confidence that the counting will be done properly and be done by the deadline. The whole country will be waiting to see Nevada's results. How embarrassing would that be? If you care more about power than about ballot secrecy and security and the people's confidence in the voting process, then you'll vote yes. If you care more about power than the faith and confidence that people have in the tabulation results, then you'll vote yes. But if you care more about the most basic and sacred privilege that we have in our constitutional republic, a secret and secure voting process, and faith and confidence in the tabulation results, you must vote no on AB 4. Thank you.
Caller with the last 3 digits, 917. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good evening, ladies and gentlemen. My name is Logan Gifford, Logan-Gifford. First, before I begin my remarks, I want to say thank you for doing the people's work. It is late. I'm a political nut, and I just love this sort of stuff, so that's why I'm up listening to you guys. Thank you guys for doing the people's work. But in regards to Assembly Bill 4, I wanted to speak in opposition to it because the Review Journal came out with an article stating that about 6,000 ballots couldn't be verified through the signature process. Either they had to be scrapped or whatever issues occurred. Moreover, the integrity of our elections and the normalcy that the nation's trying to attempt to restore by allowing sports to continue, although with no participants, we need to keep the memento going in this direction. Unfortunately, as we all know, COVID-19 isn't going anywhere, and I think the ridiculous spending increase in order to fund the elections are unnecessary at this point when we have a lot more pressing issues at the moment. I mean, the Clark County School District is short $38 million this year to even operate, and now they're doing distance education. More money towards a system that the Secretary of State said that could be ran effectively tonight, saying that she could put on a safe and secure election, just doesn't make sense to me as a citizen. I don't work for a partisan agency. I'm not anyone in particular. I'm just a Nevada citizen, and I just don't understand why AB 4 is absolutely necessary. So thank you guys for the work that you do. Thank you guys for listening to me. Have a great night.
Caller with the last 3 digits, 415. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Joe Acosta. That's Joeacosta. I'm a Nevada citizen. I know there are weaknesses in voter by mail, and there are plenty. There are logistical complications. It provides leverage for voter fraud, coercion, increased ballot rejection, and decreased voter turnout at specific cohorts. Fully transitional voter by mail in 6 months for president election will only increase these risks. Voter by mail fraud can be achieved in numerous ways. Consider duplicate voting. In eastern regions and small states, voters needed only to drive a few hours to register in an additional state and ultimately receive 2 ballots and 1 in the mail. Consider the forwarding that the U.S. Postal Service process has, which could take up to 21 days. If a resident has not put a forward into the mail system, they will not receive that mail-in vote. Consider the time period for the validations of the signatures. Consider the fact that the majority of the signatures that were rejected were Democratic voters that were rejected for lack of signatures versus Republicans, even though this is a Democratic-led bill. I urge you to vote no to AB 4. Thank you.
Caller with the last 3 digits, 401. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is Jesse Law, Jesselaw, citizen in Clark. Nevada citizens are losing their jobs, their businesses. None of you supporting the bill are pushing to fix the most broken unemployment program in the country during the biggest economic crisis of our lifetimes. For those who do work or are looking for work, their children won't be going to school but a handful of days at a time, crippling the lives of Nevada families. Parents are feeling like failures before the school year has even started, not knowing what to do for their children and teaching different ages. Their children are at risk of missing critical developmental milestones. This governor shut down their churches, stealing their First Amendment right to assemble and worship God. Nevada, your constituents, are losing everything with no ability to redress their grievances. Who is their voice? My 2-minute public comment? Their letters? There's thousands of letters that aren't even being read. And instead of calling a session to work on these many issues and reining in the governor gone mad with power, you're all here passing legislation in the middle of the night to fix a perfectly working voting system against the advice of the chief election official of the state, and in fact, without her input and participation. This is the middle of the night. This public received no official notice because the governor and his party, you, know precisely what you're doing here, stealing in the election. You're making sweeping changes and adjusting ballot security signature verification protocols, allowing ballot harvesting and people to, other than the voter, to sign the ballot and so much more. And you think the Nevadans who are suffering won't think you just stole the vote from them? This is more than shameful. Let me put it in terms that you can understand. Your actions tonight will resonate in every fearful home in Nevada, and Nevadans will remember precisely that you tried to steal their vote. I urge you to vote no. Thank you.
Caller with the last 3 digits, 527. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Kimberly Fergus, KIMBERLYFERGUS. Boy, after all those great reports and comments from people, they took all the words out of my mouth, except for I can say that I am speaking for hundreds of people that have called me crying and saying they are scared to death of this mail-in ballot. How these people, their representatives, will not return their calls. They will not. They've been writing. They've been calling. And I just urge you to please listen to the people. Don't listen to your party. You were voted by your constituents, and they want to go vote in person. They are like 80 years old and never seen this stuff happen. And I have such compassion for these people. And so I am staying up late talking when I don't even hardly know what I'm saying because I'm so dead tired. But please vote no against this bill. We have a great system. Let them go vote in person. They're big people. If masks work, then let them put a mask on and social distance. But please, listen to the people, especially the ones that are old, the 80-year-old ones that want to go vote. That's their civic duty. That's their right. They fought for this country. They fought to vote. And I'm just begging you to oppose this bill. I think it's crazy. Thank you.
Caller with the last 3 digits, 767. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is John Young, JOHNYOUNG. Earlier, Oregon was used as an example. It is an example of the failing of mail-in voting, ripe with fraud. Thousands of ballots were not even delivered by the Postal Service, and thousands of voters were robbed of their voting rights, disenfranchising many voters. Also, it is unfortunate that this is being pushed through in the dark of the night. It will unfortunately reinforce the belief in those who have not taken the pandemic serious that the emergency was only used to push a flawed voting system that will, without any doubt, lead to fraud and flawed results that cannot be believed by either side, Democrat or Republican. Mail-in voting fails every time it is used. Mail-in voting is voting fraud. Absentee balloting already exists for those that need it. This is an unnecessary action. Thank you for your time and letting me give voice to the thoughts of many Nevadans.
Caller with the last three digits, 907. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Lee Hoffman. That's Leehoffman. I'm calling from Elko. I oppose AB 4. I know that my testimony tonight is futile because real debate is no longer a feature of our legislature. The outcome is fixed, and you have all already decided. However, I feel like I need to make a statement. AB 4 is unnecessary because the process already exists for anyone who chooses to do so to receive an absentee ballot and not put their health at risk. It is unnecessary because about 50% of the voters in 2016 and 2018 voted early, and so there is no need for long lines. AB 4 is unwise because undeliverable ballots and ballot harvesting create huge opportunities for fraud. It is unwise because it incurs millions of unnecessary dollars in cost. It is unwise because it creates a dangerous concentration of power in a single elective office. There is a good reason why elections are under the control of the Secretary of State and not the governor. It is unwise because it's a huge mistake to pass a 100-page bill without the opportunity for legislators and public to fully review and understand it. That is, of course, unless you believe in that famous quote, we have to pass it to find out what's in it. As a fourth-generation native Nevadan, I cherish my right to vote. You talk about disenfranchising voters, but there are other ways to be disenfranchised. I am disenfranchised when someone else votes twice or votes when they are not eligible. AB 4 is not an example of open, transparent government. It is an obvious power grab conducted under cover of an unjustified COVID panic at the behest of a dictatorial governor. I urge you to vote no on AB 4. Thank you.
Caller with the last three digits, 618. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Matthew Montagnesi, spelled MATTHEWMONTOGNESE. Thank you for your work. I am a native Nevadan, and I oppose AB 4. I support absentee ballots and free will. I haven't even had the chance to read this 100-page bill as I have been listening here. I also support the American liberty to vote in person on Election Day, as we will have through pandemics past like the Spanish flu of 1918. Our schools will be partially open. I wish more in Washoe County, and so should our ballot boxes be. I personally received 2 mail-in ballots and responsibly destroyed them both and voted early in person. I did not contract the virus, as the booth was manned responsibly with preventative measures, as was I, using PPE. Citizens who are willing and capable of shopping and using healthy choices cannot be met by safe and convenient ballot boxes handled in a safe manner is a catastrophe to me. Let's encourage our people to be responsible if they are willing to vote on site to see their choices visibly on a printout. Keep voting safe and secret. Thank you for your time.
Caller with the last three digits, 524. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Gail Combs, GAILCOMBS. I'm a registered Nevada voter, and I'm calling to urge you to vote no on AB 4. It puts the integrity of our election at risk. If fraud and ballot harvesting can be legalized, it makes it possible for anyone that could go door to door collecting ballots and taking them in or changing them or whatever they choose to do at that point. And we already have in place safety precautions that prevent and allow people who don't want to go in. They can vote by mail already. They can have an absentee ballot. We don't need to put this in place. It's already there for the people who are afraid. And if we can shop, or the kids can go back to school and we have masks and we can protect ourselves, we can surely go to the polls and we can surely social distance and we can surely exercise our amendment rights. And I ask you to strongly vote no and don't take away our constitutional right to vote.
Caller with the last three digits, 224. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Andrea Young, ANDREA YOUNG. I am requesting a no vote on AB4. To only allow mail-in voting is to assume voting should never be an inconvenience. Safety in life is never guaranteed. You could get in a car accident and die on the way to your mailbox. No one should have their freedoms taken away because a select group that claim we cannot be free due to a virus. This, of course, could then occur every flu season during an election year. The government could then manipulate all of our rights for the sake of our health. The fact that you're holding this meeting this late at night tells all Nevadans everything they need to know. Thank you.
Caller with the last three digits, 625. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Yes, Maureen Morris, M-A-U-R-E-E-N. Last name Morris, M as in Mary, O-R-R-I-S. I'm asking you to vote no on AB4. Our system is great. It works. Mail-in voting encourages fraud. Also, we're being disenfranchised as voters by denying us the right to vote in person. Precious dollars the state needs to recover from the effects of the Sisolak shutdown should be nonpartisan issues. Please vote no on AB4. Thank you.
Caller with the last three digits, 389. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, this is Jimmy McKee. It's spelled J-I-M-M-I-M-C-K-E-E. I am opposed to AB4. Currently, anyone that wants to ask for a absentee ballot can do so and vote by mail. The rest of us that choose to go out in person and early vote or just vote on the day of the polling can do that as well, and we should be able to. I hear a lot of people that were for the bill, and all of those are lobbyists. This does not represent the people of Nevada, nor does rushing this bill through in the dark of night, it's 11:40, when most are sleeping. This only indicates how corrupt this actually is and not transparent. There are people out there all over the place, in case you haven't noticed. Traffic is terrible. People are shopping. People are going to the gym. They're doing everything else. They can certainly go and vote. Most people want to go to the polls. Those that don't can, as I said, vote absentee and ask for that in advance. This is a perfect opportunity for fraud. Yes, you have penalties, but like speeders, there are not enough of the cops to catch the criminals. It is our right to vote, and this bill violates our rights. Stop using the COVID as a political pawn. Let those that want to go to the polls, and those that want to have absentee, have absentee. Thank you.
Caller with the last three digits, 318. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Teresa DeGraff and Reed, T-H-E-R-E-S-A, DeGraff and Reed, D-E-G-R-A-F-F, as in Frank, E-N, REID. Thank you for hearing my testimony. I am strongly opposed to AB 4. The Secretary of State's office testified earlier in the Assembly that they had plans in place to safely and effectively hold an election with a combination of early voting, in-person election day voting, and mail-in ballots for anyone who wants one. Maybe it made sense back in March to be cautious with a primary election when we didn't know much about how widespread the virus would be or if our medical facilities would be able to keep up. But we see now that we are able to safely go to work, patronize restaurants, casinos, and other businesses, buy groceries, and go to Walmart and Home Depot using social distancing and wearing masks. There is no reason why we cannot do the same for something as important as casting our vote. I would point out that even though this bill was unveiled for the first time late this afternoon, there are already over 650 opinions on this bill, of which only about 20 support this bill. The vast majority of regular Nevadans are opposed to this bill, as am I. Please vote no on AB 4. Thank you.
And we will go ahead and take our final caller for the opposition, and then we will move to neutral testimony.
Caller with the last three digits, 373. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Janet Freitas, JanetFreitas. I am the president of the Nevada Federation of Republican Women, and I do speak for the Nevada Federation of Republican Women, which is about 1,200 members strong. We strongly oppose AB 4 and do strongly support Secretary of State Barbara Sagaski and her committee to run safe and fair elections. We have plenty of early voting time as well as absentee ballots if you wish to ask for that if you are afraid. And on the subject of ballot harvesting, which is currently a felony in the state of Nevada, I find it very hard to understand how we can sweep that under the rug and change that in the middle of the night. Also, if you can receive mail, you can turn around and put mail outgoing so that there is no need for ballot harvesting. If you can receive a ballot, you can mail a ballot. Thank you very much, and please vote no on AB 4.
We will now move to our neutral testimony. If you are neutral on Assembly Bill 4, we will begin testimony for the neutral position.
If you are in neutral, please press *9 now to get your place in the queue. And we will take callers in order. Caller with the last three digits, 783. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Frances Dean, Frances, Dean, Deane. I represent the nonpartisan network here in Nevada, and I want to remind all of you that there are 367,000 registered nonpartisan voters in this state. I want to thank you for allowing public comment on this particular bill. I stand neutral because I know that the decision has already been made on how you're going to vote for this, but I wanted to just make a comment. So I listened to the Assembly and I listened to the Senate, and I am apparently the only one that believes that the state of Nevada legislature is not prepared or skilled enough to maintain my safety and my health. You're not doctors. Nowhere in NRS does it state that you are, your role in my life is to keep me safe by controlling how do I get to decide to vote. But I'm good, but thanks. And I wanted to
also point out that we have a beautiful group of contact tracers, and I'm sure that there are a lot of people on the list of contact tracers who have recovered from the corona. Perhaps that they could be pressed into service, call it their patriotic duty to work at the polls because they have already recovered from the coronavirus. I stand with Madam Sagatsky, the Secretary of State. The fact that this is being heard in the middle of the night with so little notice says more about the legislative body that I'm talking to right now than it does her office's abilities to handle an election. It appears to me that this bill is a pure power grab, and I oppose that. I applaud Barb Sagatsky for her honest answer earlier about when she had received a copy of this bill.
If you could go ahead and wrap up, and if you could go ahead and wrap up, and I'll remind.
I'm almost done. I'm almost done. She's the only Republican constitutional officer, and the governor's attempt to undermine the Secretary of State's authority on elections is only so clear that you are strong-arming her decision-making.
We're past the 2 minutes. If you could go ahead and just wrap up.
State, not the governor's office. So please vote no. Prove that you are a nonpartisan body. Vote no. Thank you.
I will remind just all of the callers, we are on neutral testimony, and we'll only be accepting neutral testimony. We do have an opportunity if you'd like to have your written comments submitted, but you can do so using the email instructions on our agenda. We'll continue with neutral testimony.
Madam Chair, that concludes neutral testimony.
Okay, great. Thank you. And thank you very much for helping to facilitate our public comment this evening. We appreciate it. And as always, appreciate the ability to that we've found to separate out that testimony. With that, we will go ahead and close the hearing on Assembly Bill number 4. What is the pleasure of the committee? Senator Brooks.
Madam Secretary, I move that we do pass.
There is a motion to do pass by Chris Brooks, a second by Senator Kinsella. Any discussion on the motion? Senator Hansen.
Thank you, Madam Chair. I think, like so many people just reflected, this is a disgrace that we're doing this in the middle of the night, that we get a bill that's 62 pages long, involving 84 sections of law, and we rush it through in a hearing like this. The whole thing just stinks to high heaven. It is not necessary to have this in a special session. This is a huge change in law, and the idea that it got dropped 1 hour to the Secretary of State before the Assembly hearing started is just bizarre. And so I would just urge my colleagues to vote absolutely no on this. It's an embarrassment to the legislative process, and it brings dishonor to this body. Thank you, Madam Chair.
Further discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye. Any opposed? If you are a nay, if you could please raise your hand so we can have a proper record of that. Senator Hansen, Senator Gocochea, Senator Hardy, Senator Settlemeyer, Senator Hammond, Senator Pickard, Senator Ganser, Senator Kiekever. Motion carries. Assembly Bill number 4 will be reported to the floor of the Senate. Ladies and gentlemen of the committee, that does conclude our business on this particular agenda. Senator Woodhouse.
Thank you, Madam Chair. I move that the Senate Committee of the Whole do rise and report to the Senate.
Senator Parks.
Thank you. I second that motion.
You've heard the motion. Any remarks? Seeing none, all those in favor, please signify by saying aye. Aye. Any opposed? Motion carries. The Committee of the Whole is dissolved, and the Senate will be in a brief recess.
Senate will come to order. I have a challenge. I was challenged to see if I could get this done before we started a new day, so let's see if we can. All right, order of business number 4, reports of committee.
Madam President, your committee of the whole to which is referred to Senate Bill number 4 has had the same under consideration based on the report, same back recommendation do pass. Signed Senator Nicole Canizaro, Chair. End of reports.
Thank you. Order of business number 16, remarks from the floor. Senator Canizaro.
Thank you, Madam President. I move that the Senate stand in adjournment until the hour of 11 a.m. on Saturday, August 1st of 2020.
Thank you. You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Senator Parks, am I doing okay here? Oh, good. All right then. Motion passes. See you guys tomorrow.